всім! Дуже раді
Good
вітати
morning,
усіх
dear colleagues. We
сьогодні
are very
в стінах
happy
нашого
to
багаторічного
welcome you
партнера
here
Львівського національного
at
університету імені
Lviv
Івана Франка
State
на
University named
11-му
after
щорічному
Franco at
міжнародному
the
форумі з
11th
практики
annual
Європейського суду з прав людини.
forum
Насправді
on
це
the
є
case law
визначна
of
подія для
European
нас.
Court
У нас
for
є
Human Rights.
щорічні низка
That's a
щорічних форумів,
remarkable
платформ,
event for
але
us. We have
цей форум він є
several
унікальною
annual events,
площадкою
but this
для
international
спілкування
forum is a unique
правників,
platform
представників юридичної професії,
for
суддів,
representatives of
адвокатів,
all legal professions,
студентів, державних
judges, defense
службовців,
lawyers,
представників
students,
з
civil
різних
servants,
урядових та неурядових
representatives of
організацій з актуальних питань
NGOs,
захисту
public
прав людини та
organizations, human rights
практики
activists,
Європейського суду з прав
and
людини. І я з
those
приємністю
working
хотіла би
in
надати слово пану Сергію
and
Різнику,
on the
доктору
issues of European
юридичних наук,
Court of
проректору
Human Rights to get
Львівського
together and
національного
discuss it.
університету
Let
імені
me
Івана
give the
Франка
floor
для
to
привітальних слів. Будь ласка.
Mr. Malnik, rector of Ivan Franko National
Щиро дякую,
University,
пані Наталя, ми шановні
with welcoming
колеги, ми
remarks.
шановні гості
Thank you,
Львівського
dear colleagues,
університету,
dear
ми
guests of
шановні
Lviv
гості
University,
України і ті,
dear
хто
guests, welcome
долучилися до
to
нас
Ukraine.
онлайн, і ті, хто зумів
Thanks a
прибути
lot
сьогодні
for
до
being here
Львова.
with us.
Дозвольте
Thanks
мені
a
від
lot
імені всієї
for
академічної
getting connected
спільноти
with us online.
Львівського
Let me, on
університету
behalf
і
of
персонально від ректора
Academia of
Львівського
Lviv
університету
University and
професора Володимира Мельника
Rector of
привітати
Franco
вас
University,
і
welcome
нас з
you
11-тим
here
уже
and
щорічним
welcome us
форумом з
here
практики
on the
Європейського суду з
11th
прав людини для Львівського
annual
університету.
international forum
Це
on
без
the case law of
перебільшення
European Court of Human
велика
Rights.
честь, що
For
так
the
стабільно,
university, it's a
широко,
big
тільки, якщо я не
honor
помиляюсь, один рік
that
ми пропустили з,
we
на
are
жаль,
organizing this
страшної
forum
причини початку
here
повномасштабного
regularly. We
вторгнення
missed it only
на
once.
територію України, але я
That
впевнений,
was
що ми цю
due
традицію будемо
to full-scale invasion
продовжувати, тому що
of
значення,
Russian Federation
власне,
into
тієї
Ukraine. But
роботи
this
і практики
tradition, I'm sure,
Європейського
is going
суду
to be
в нинішніх
continued
умовах
because
особливо
the
важлива.
significance
Ми
of the
тут
European
у
Court case law
Львівському
is
університеті, як і в
acquiring
різних
even
спільнотах,
bigger
але мені
importance
здається,
now.
що в академічних
In
спільнотах це
Lviv,
особливо
similar to
відчутно.
other
Бачимо,
academia, we
наскільки атакується не лише
feel
наша територія, не лише наші
how it's
міста і
not
села
only the
атакуються.
territory, villages and towns of Ukraine that are subjected to attacks, but these are humane values, the values that we believe and share are subject to attack. Unfortunately, these values are not recognized by all and every state. I think you will support me when I say that so-called Russian people are united by anti-value and anti-values, and this makes them strong enough to wage this war for such a long time. But we will prevail and we will win shortly. Lviv University organizes a lot of different events on the issues of international law, on legal issues, and that's all done to support our much expected victory. Dear friends, you can always rely on Lviv University, on the faculty and students of our university. We will fight for democracy, rule of law, and human rights, and we will prove to the world that our victory is evidence that democracy is much more effective than authoritarianism. Thank you, Sergei. We enjoy cooperating with you for all this year. I remember how back in 2012 we joined the initiative of Lviv University to organize the international forum here, and we tried to do this since then, despite all challenges. The studies, the classes are there, and Lviv University life goes on, and we appreciate that with us there are judges of the European Court of Human Rights. Unfortunately, many guests joined online, did not come physically, but hopefully in the future we'll be all here in Lviv. Let me give the floor to another partner, that's Supreme Court, Alexander Mamalu, Deputy President of the Supreme Court. Over to you. Good morning, dear colleagues. I am very happy to join in and participate in this really very important event organized in Lviv. Let me thank everybody who made this event possible. In particular, that's Council of Europe project support to the functioning of justice in the war post-war context in Ukraine, and the project of the OSCE promoting responsive professional judicial education, Lviv University Legal Department and National School of Judges. Let me also note the role of Dmytro Gudima, the judge of the Supreme Court, who was the initiator of this event back in 2012. I'm really happy to see the European Court of Human Rights judges here. Thanks for joining us. Your presence is a sign of solidarity and support to Ukraine. Legal department of Lviv University has a remarkable faculty, and the team of the two projects, OSCE and Council of Europe, made this event happen. The war changed the context in Ukraine, and it makes it much more difficult to accomplish the goals and enforce human rights in Ukraine. That poses new challenges to the legal professions, but we all join our efforts to make sure that human rights are enforced despite all this dire situation in the country. Support of our international partners on this path is extremely valuable. The challenges posed by the armed aggression include the way Ukraine applies Article 15 of the Convention on Human Rights that provides for derogations from the convention during the war. The government is vested with the duty to thoroughly assess, and the courts should carefully assess the limitations to human rights as to their proportionality and relevance. The war is something that unfortunately has always been accompanied with violence and destruction. But it requires proper mechanism of restitution so that everybody who was subjected to any type of harm or damage would have it compensated. Register of damage that was created shows that Council of Europe is really proactive in making sure that damage is compensated. We do hope that these mechanisms will lead to compensation being paid out of aggressive power assets. There is also the necessity to create mechanisms to bring to accountability the perpetrators. Thus will provide for fundamental principle of reversibility of punishment. And one of the main tools here should be fundamental principles and criteria of the European Convention and the way they are interpreted by the European Court. Apart from defining the areas to work in the future, we need to look at the way the standards of the Convention are applied by the National Court. The Supreme Court keeps publishing monthly assessments of the national case law. And there we keep referring to the case law of the European Court. We are in close communication with the European Court via the Supreme Court network. Let me just note that the Supreme Court within its mandate is actively working to make sure that European Court judgments are fully executed in Ukraine. Thus, we try to prevent similar violations in the future. I wish you all fruitful work. Thank you. Thank you, Alexandra. Thanks a lot for your involvement in the event and participation of the Supreme Court judges in this event. Another partner of this annual event is National School of Judges. Let me give the floor to Natalia Foley, the researcher in charge of the training at the National School of Judges. Over to you. Good morning, dear participants of this forum. I'm happy to see those who are here in this wonderful room and those who are connected with us via Zoom. 11th International Forum, and that's very important to have this type of fora. It's very important to continue traditions amidst the war. National School of Judges is an active participant of many events and projects, but this event is of special importance, both for the judges and for the School of Judges as the institution. So let me welcome all of you here on behalf of the school and on behalf of the rector, Mr. Onishuk, at this forum. And I believe that discussions and presentations that we are going to have at this forum are sure to contribute to making sure that the judiciary is ready to face the challenges that we are having now. Let me just say that the National School of Judges, similarly to many courts in Ukraine, receive judgments of the European Court that came into force, where unfortunately some issues are stated, and the words systemic and structural problems are mentioned there, and we are going to hear them mentioned in this room. Some of the European Court judgments are similar in a way, in part, and thus it's very important when responding to the challenges caused by the war to clearly figure out how we can address those issues that are still pending. I wish all of us fruitful discussions and looking forward to the presentations. Thank you, Tatiana. We have been closely cooperating with the Ombudsman of Ukraine. We have Taras Nadvirny, representative of Ombudsman in Lviv Oblast. Over to you. Good morning, dear participants of the forum. Let me thank the organizers for resuming this fora in Lviv. For us, that's a special event. Lviv University graduates were among the founders of developing the concept of human rights. Hershey Lauder Hapte is a graduate of our law school here in Franco University, and for us it's very important to continue the tradition with respect to human rights in Ukraine. Let me on behalf of Dmytro Lubinets, the Ombudsman of Ukraine, reassure you that human rights remain a fundamental element of our work. In our strategy until 2027, we singled out a special section on human rights to underscore the importance of advocacy and importance of the enforcement of human rights judgments. Practically speaking, we try to make sure that through preventive work we'll reduce the number of violations in respect to Ukrainian citizens that might lead to their applications to European Court. I wish all of us fruitful discussions. Thank you, Taras. Let me give the floor to Maciej Janczak, head of the office, representative of the Secretary General of the Council of Europe and the coordination of cooperation programs of the Council of Europe. He's going to join us online. Thank you.
Доброго ранку, дорогі друзі.
Good morning, dear friends.
Dear friends, distinguished judges, ladies and gentlemen, I send you my greetings from Kiev. Unfortunately, I was not able to join you this time in person, but I try to do my best that next time I will be there. I am honored to welcome you all to the 11th International Forum on the Case Law of the European Court of Human Rights. Today's event is organized by the Council of Europe through our project focused on supporting the functioning of the justice in the war and post-war context in Ukraine, jointly with the OSCE support program for Ukraine within the framework of the project on promoting responsive professional judicial education. In order to make this forum possible, we have cooperated very closely with our national partners, the Supreme Court, the National School of Judges of Ukraine, and the Law Faculty of Ivano-Franko National University of Lviv. Dear friends, it is very important to recognize the magnitude of challenges brought about by military aggression of the Russian Federation against Ukraine, which has been ongoing for nearly 22 months already. Actions aimed at strengthening the resilience of the country and the commitment of the national stakeholders, including judiciary, through this period are truly impressive and deserve the highest respect. I would also like to mention that the Council of Europe was very swift to react to the Russian aggression. The aggressor state has been expelled from the organization only a month after it happened. And then, very quickly, the Council of Europe, working closely with the Ukrainian authorities, started to devise an action plan for Ukraine called Resilience, Recovery, Reconstruction to help the authorities in implementing these three important elements, strengthening resilience, recovery, and reconstruction of the country. Today's forum is a good example of effective cooperation through which the Council of Europe actively supports the efforts of the Ukrainian partners in implementing the mechanisms designed to address a number of systemic and structural issues. The forum is dedicated to the discussion on the current case law of the European Court of Human Rights in the context of war and national practice, as well as execution of the European Courts of Human Rights judgments by Ukraine. One of its aims is to consider how Ukraine could further enhance the implementation of the Council of Europe standards with a view to increasing the efficiency of the justice system in the areas of human rights, rule of law, and democracy. It will also strive to assist Ukraine's efforts in meeting its obligations as the Council of Europe member states. Dear participants, it should be stressed that the standards of the European Convention on Human Rights continue to apply in the context of the war, and thus any case may be subject to the scrutiny of the European Court of Human Rights, including the legislative framework that may serve as the basis for the prosecution and trials. In this context, it is crucial now to ensure that war-related cases are considered in line with the relevant standards. This is a question of justice for victims and the whole of society. To participate in our forum, we have invited a number of distinguished speakers, including judges of the European Court of Human Rights, Madame Ivana Jelic, Mykola Gniatowski, Peter Pacholai, Latif Husseinov, Mr. Armen Hartunyan. We also have our colleague Dmytro Tretyakov, a lawyer working for the European Court of Human Rights. Colleagues from other segments of the Council of Europe will also take part in the forum. I would like to express our most sincere gratitude to all the distinguished participants for making this event an extremely important and relevant one. The level of speakers testifies of the attention attached to the human rights, but also to the European Court of Human Rights, which is one of the most important elements of the European human rights protection architecture. Dear friends, the Ukrainian authorities, just as the authorities of all other member states of the Council of Europe, are obliged to protect human rights through effective implementation of laws, practices, and effective execution of the judgments of the European Court. They need to ensure inter alia the right to a fair trial and effective access to justice for all. It thus seems justified to hold regular and informed exchanges and sharing best practices in this context. The forum creates a space to do just that. The Council of Europe stands ready to continue supporting these processes. Some of them will be supported in the framework of the projects operating within our Kyiv office. At the same time, it needs to be stressed that the primary responsibility for human rights protection and for undertaking required actions lies with the Ukrainian authorities. There should be a firm political will and strong commitment to ensuring the success and sustainability of all these crucial undertakings. We are confident that the Ukrainian society is determined to continue its strive for further enhancement of the rule of law and legal certainty, as well as promoting human rights and strengthening democratic principles. We are here to support you in this endeavor. Once again, let me thank the co-organizers of today's forum for having this opportunity to discuss actual case law of the European Court of Human Rights and developments in the sector of execution of the court's judgments. I wish you all an interesting and productive 2 days of debate, and I thank you for your attention.
Дуже дякую, пане Янчак, і я дуже вам вдячна за ту синергію, яку ми досягли.
Thanks a lot. I appreciate the synergy that we accomplished in Ukraine within the rule of law and human rights and democracy projects. So that's a really very good cooperation. Let me give the floor to the OSCE representative. As you know, the mandate of the OSCE was not extended in Ukraine due to lack of consensus. And since last year, we have the support program implemented in Ukraine with delegated mandate. So the project that organized this event is involved in the work of justice. So they have the mandate of ODIHR. So let me give the floor to Julia Gerhard, Deputy Head of the Department for Democracy of ODIHR. Over to you.
Thank you very much. I'm honored to attend today's event, and I'm really grateful for the invitation to speak. I'm addressing you on behalf of the OSCE's Office for Democratic Institutions and Human Rights today from Warsaw Online. First, I would like to thank the event's organizers, including the Council of Europe, Ukraine's Supreme Court, the National Academy of Judges, and Lviv University. Additionally, I would like to thank the offices for the OSCE's support program for Ukraine, which in coordination with ODIHR continues to organize events like this, which highlight the important issues confronting Ukraine's judiciary during times of war. As Russian military attacks against Ukraine continue to devastate Ukrainian families and communities on a daily basis, judicial institutions are, of course, also impacted. ODIHR recognizes that aside from the horrific toll that these attacks have on victims, on communities, on public infrastructure and services, the attacks also threaten the rule of law, including legal professionals and the administration of justice. The more than 100,000 reported war crimes have caused an intense strain on the judiciary, posing new challenges to courts and various judicial actors. Despite this enormous pressure on the courts, ODIHR applauds Ukraine for its efforts to strengthen the rule of law and human rights protection during these times. Events like the one today embody Ukraine's affirmation to the OSCE principles on human rights and democratic commitments, which provide that participating states will endeavor to ensure that the legal guarantees necessary to uphold the rule of law will remain in force even during a state of public emergency or war. The OSCE Ministerial Council's Helsinki decision on rule of law from 2008 has additionally called on OSCE participating states to honor their obligation under international law and to observe their OSCE commitments regarding the rule of law at both international and national levels in all aspects of their legislation, administration, and judiciary. I also recall that OSCE commitments further state that participating states will fulfill in good faith their obligations under international law, particularly through promoting and encouraging the effective exercise on civil, political, and other rights and freedoms, all of which derive from the inherent dignity of the human person and are essential for his free and full development. Collectively, these OSCE commitments call on all OSCE participating states to guarantee that rule of law is functioning and that human rights are protected in accordance with international law, also during times of war. For our part, ODIHR and the support program for Ukraine are eager to engage and to support Ukraine in further strengthening and upholding the rule of law, including its efforts to advance accountability for war crimes. Since the full-scale invasion in February 2022, in partnership with Ukraine's Supreme Court, ODIHR has hosted so far 5 events for over 150 Ukrainian judges who confront large dockets of war crime cases. These seminars and webinars have focused on how international humanitarian law, international criminal law, and the ECHR case law can be applied in the context of Ukrainian decisions. Apart from various substantive areas of law, for example, command responsibility, prisoner of war status, contextual elements of international crimes, and also procedural issues such as admissibility of evidence in absentia cases and standards. ODIHR has prioritized the use of practical exercises on drafting for judges so that decisions are not vulnerable to procedural challenges and appeals before the ECHR. ECHR case law, of course, does not matter only to judges, but also to defense attorneys who are responsible for ensuring that all defendants receive a fair trial, even when they are tried in absentia proceedings. In this event today and in future events, ODIHR will utilize the knowledge and experience of judges and defense attorneys from fellow OSCE participating states who had similar experiences in dealing with substantive and procedural cases and can share lessons that they have learned in their own experience for finding accountability for war crimes. In conclusion, I encourage you all to utilize ODIHR services in your efforts to further strengthen and uphold the rule of law and application of international standards during times of war. ODIHR stands ready to support judges and judicial professionals in their effort to uphold the rule of law and ensure accountability for violations of international humanitarian law and international criminal law. I wish you a productive and engaging forum. Thank you very much.
Дякую, пані Гебхард. І щиро вдячні, що ви віднайшли можливість приєднатися сьогодні до нас.
Thank you indeed for joining our event. At this, we finish our introductory remarks. In front of us, we have quite intensive work. Oh, yes, I am really sorry. The floor is given to the Dean of Faculty of Law. Our university thank you. You might have heard that I'm afraid I would abuse a bit the time that was given to me. So, esteemed participants, esteemed justice, this is really an important event taking place at our university, but this confirms the reliability of our partners of our university hosting this event, remaining the scientific and academia center. In fact, this forum has become kind of a business card for our university, and I know then when it's over, literally next day, our colleagues start preparation for the next one. And the speeches delivered here are often mentioned in international publications. So, as I said, I will abuse my time a little bit to draw your attention to some problems. I'm not very knowledgeable of the case law of European Court. I'm criminalist, but actually this case law is now part of legal system of Ukraine. But what I can see is that some judgments of European Court, if you look at the judgments of Ukrainian courts, I observe certain, exaggeration of respect for human rights. Yes, indeed, this is a very important point, but they need to be correlated with the interest of the society. What are the natural rights? Something given us for good. I don't want now to mention specific criminal cases like James Bodger murder in the United Kingdom when a white child was kidnapped. The child was 3 years old by 10 young men, 10 years old. The child was beaten and then thrown underneath a train. And certainly significant traumas were caused, like 12 breaks of the skeleton. But actually the European Court drew attention to the fact that during the judicial review, and it was an open judicial trial in the court for adults to take into consideration as applied to the 11 years old teenagers as an intimidating procedure. You remember Ukrainian case Petukhov versus Ukraine, who was convicted for several episodes of murder and attempt to kill a law enforcement officer, and he was deprived of freedom. But then, through the European Court, he actually managed to receive conventional conviction on probation. But the story behind that is quite interesting. Initially, the convention allowed for death penalty by court judgment, and nothing was wrong about that. In 1983, there was Protocol 6, which restricted application of the penalty with only exception of war crimes, and then later that penalty was recognized as unacceptable. By the way, the Constitutional Court had recognized the unlawfulness of the penalty yet before the respective judgment of the European Court. So it was replaced with a life penalty. But what do we do later on? Then we start dismantling this construct by providing life imprisonment as something that can be replaced with conviction on probation. It reminds me of soup which has no enough salt, and when somebody eats it and says that the salt is missing in the soup, and also the cook is blamed of that. Thank you indeed, Volodymyr.
Проти Сполученого Королівства Великобританії і право на надію.
That reminds me of our discussion about winter case
Можливість обговорити всі ці питання
versus United Kingdom and some other cases. Thank you indeed for your cooperation and interaction with a number of projects related to reform of legal education in Ukraine. And now I suggest that we move forward to session 1. Today we work till 6:30 p.m. We'll have lunch break from 12:30. If air raid alert is announced, then we will have to go to the shelter and suspend no discussions. Now, for the floor to Marta Machursky, Deputy Dean of Lviv National, Deputy Dean of Department of Lviv National University. Good morning, esteemed colleagues. I'm really pleased today to moderate the first session of our international forum. I have participated in a number of previous forums, so probably all participants are looking forward to interesting speeches and expert opinions of famous lawyers, both national and international. The key speech unfortunately deals with very relevant subject matter for Ukraine, its protection of human rights during the war. That's the painful matter for any Ukrainian, and it's a continuous challenge for us. We have to look for mechanisms to ensure protection of these rights, especially during the war, with maintaining the already existing mechanisms. I'm inviting to the floor the Justice of the European Court, Mykola Gnatovsky. He'll speak online. Good morning, esteemed colleagues. Thank you indeed for the floor. Thank you indeed for the invitation to take part in your forum. Indeed, this is a traditional forum, and as usual, the premises where you are certainly produces the most warm impressions, in particular thanks to the great work that was done during the previous fora. I do hope that we would be able to get together offline in spite of whatever. And this time, all our team in Strasbourg, all my colleagues who are here and who will speak from Strasbourg, we had the previous communication. We were ready actually to travel to Lviv, but unfortunately our case load now is very intensive. Still, I do hope that I will be at your university already next week. But so far, we'll have to work remotely. I'd like to greet all of you, to thank for co-organization, co-participation in this conference, esteemed Deputy Head of the Supreme Court, esteemed Justices of the Supreme Court, Ambassador Yanchak, and of course, my thanks to Lviv, Ivan Franko National University, represented here by Prorector Riznik and Dean of Faculty of Law. Also, I'd like to say that Lviv University indeed is one of reliable partners and one of the centers of human rights in Ukraine, starting from early 90s. I remember Laboratory of Law by Professor Rabinovich, which still remains very important information of transition of Ukrainian lawyers to a different notion of human rights, to answer even some basic questions from students that were mentioned by the esteemed Dean of Faculty of Law. I'd like to say that the team of European Court of Human Rights, introduced already by Natalia, is composed by my colleagues who are real experts, not only of general law, but also in quite narrow matters, which is a key topic of our forum today. So I'm looking forward into the speeches of Justice, who is former head of European Venice Commission, Justice Yavich, who is former deputy head, chair of the Committee of Human Rights of United Nations, esteemed Justice, who is former head of the Committee for against tortures, and a very experienced judge, Artinian, who has huge experience of work, in particular in Ukraine, working for UN in the area of protection of human rights. And of course, I'm looking forward to our most experienced Ukrainian lawyer, Dmytro Tretьякov. I think all these speeches will be very useful for all. Speaking about the actual subject matter of my speech, I'd like to say that it's not a secret that European Convention on Human Rights applies during the war, because the human rights are very relevant for the time. So I'd like to remind you the Constitution of Ukraine also applies during the war, where the key point is the very existence of the state, according to Article 3 of Ukrainian Constitution. So it's quite evident that human rights cannot disappear from the scene, even when matters of the very existence of the state and political nation are solved. So I think that the most important part to start with is the statement that human rights should never be viewed as something preventing Ukraine from defending itself. The human rights is what Ukraine is defending. The system of human rights is very essence and very identity of us as the nation that chose the European path of development, while other structures of Council of Europe help Ukraine defending this choice.
European Convention on Human Rights is seen by European Court as the constitutional tool of European order. This statement was stated in 2005 in Warsaw Alliance case, but it has been repeated given the large-scale war waged by Russian Federation against Ukraine that started not last year, but back in 2014. But last year it reached to unprecedented scale never seen in Europe since the World War II. We face a unique situation when we have a large continental territorial war the space where the European Convention is applied. That's the first war where in full scale the European Convention is applied. The judge will talk about derogation from Article 15 that was mentioned before. That's why I'm not going to speak about that now. But anyways, there are non-derogable rights that are fundamental given human rights protection during armed conflicts. Speaking about non-derogable rights, derogation is seldom a ground to pursue a different approach to protect these rights than the one that is provided for by the Convention, with the exception necessary in democratic society with respect to some rights that are also provided for in the Convention. Ukraine is a party to Convention, and all the events that are happening within Ukraine's jurisdiction that with respect to the persons under Ukrainian jurisdiction, these are the events that should and can be assessed in terms of their compliance with European Convention on Human Rights. The European Convention does not create obligations for the states that are not parties to the Convention. In other words, the issue of jurisdiction in the European Convention, the issue as to which state is accountable for this or the other violations is primary when handling the cases of violations during the armed conflicts. European Court has a so-called residual jurisdiction that stays there with respect to Russian Federation until September 16, 2022, until the moment when the Russian Federation stopped being party to European Convention, and it can be extended as to some other situations, for instance, custody that lasted then and continue now, but time-wise it is limited in this manner. That may sound like something fundamental, but that's very important to remember that given what is going to happen in the European Court with respect to the cases related to war, there are two ways to bring these cases before the court under Article 34 through individual complaints and interstate applications under Article 33. As to Article 34, individual applications that can be submitted under it, the court acts in dual role. That's not only with respect to the war-related cases, but in any cases. The first role is to provide for justice in an individual case where we need to answer the question whether the rights of a person in question guaranteed by the European Convention were violated. But the second important function of the court here is explanation of the protection and development of the norms of the convention. And this way to assist the government to guarantee honoring the obligations of the state under the convention. In other words, European Court of Human Rights is not just a court that can remedy the situation in individual case and state that, let's say, national courts allegedly did something not in line with the convention. The role of the court is to assist the government to systemically honor its European Convention obligations. And Ukraine is very well aware of that. And today in the welcoming remarks, we heard really good messages stated, whereby it was said that there are lots of systemic issues that have been in Ukraine always before the war and during the war, and they're still there. They have been identified by the European Court long ago, and that's part of case law of European Court. And with respect to them, European Court is received and unfortunately will receive a large number of cases to this end, and thus the court is to deal with them under accelerated procedure, because the court has nothing new to say as to issues in these cases. That's the flow of issues that existed before the war should have been stopped. Ukraine had to respond to all of them. I am not going to name all these issues, but I will be happy to answer the questions to this end if there are any later. The same about armed conflict-related cases. The answer is to be given to systemic questions, and most importantly, it is necessary to find in Ukraine mechanisms of addressing them without creating the situation with no progress, but just creating additional load, whether to the national judiciary or the European Court. Armed conflicts are problematic from the point of view of human rights, because the mechanism of the protection of the rights is involving handling individual cases. If we are talking about hundreds of thousands or millions of people that were subjected to attack or to violations during the armed conflict, apparently none of the courts at the national level or any court that receives complaints against 46 states with more than 700 million people, none of the courts will be able to handle these complaints. Therefore, these issues are particularly complex for solution. And the only thing we can do to this end is just have this dialogue of judiciary that was referred to today, that is a solution. But this has to be done on the level of regulation, legislation, and administrative practices as well, because the court can identify the issue, but the court cannot resolve this issue as lawmakers and national systems can do. So that's one thing. As to interstate applications, the state is a guarantor of the human rights protection. In the interstate applications, the state doesn't speak about the damage caused to the state, but it talks about the damage caused to people, since the state represents the interests of the citizens. That's why interstate cases are a priority for the court, although it's very resource intense and complex cases to handle. The answers to the questions raised in these cases is an opportunity to resolve systemic problems that are part of individual applications. That's why the court acts in the same manner. The court first looks into interstate cases and then moves over to individual applications related to them. Simple numbers. That's about the new stage of the armed conflict since the beginning of the full-scale invasion of Russian Federation against Ukraine. As of today, the court has around 900 individual applications. That's for the period starting the end of February 2022. Apart from that, we have lots of applications that are related to the armed conflict that started in 2014. Out of this 900, we have 680 against Russia, around 200 against Russia and Ukraine, and around 20 against Ukraine. As to the previous stage of the war, we had around 6,600 individual applications in the court now. That's regarding the events in the east and Crimea linked to interstate applications. So 7,500 cases, that's the cases that are this way or another linked to this war, and this number is likely to increase since Russian Federation is excluded from the system, then the percentage of the cases against Ukraine and their share might increase. The court is going to look into interstate cases that will serve as the basis for addressing individual cases. On December 13 this year, we are going to have a hearing in interstate case Ukraine against Russian Federation. That's regarding Crimea. And we hope that the court will move over to the stage of delivering the judgment on the merits of the application, because the application was found admissible by the court earlier. The next is another big interstate case that primarily dealt with the events in the east of Ukraine, and then the Netherlands added its application with respect to Malaysian Airlines flight MH17 to it, and it is really very important that we merge this application, having found its admissibility. The 10th interstate application of Ukraine against Russia that deals with the events following large-scale invasion. That's Ukraine and the Netherlands versus Russia. That is going to be adjudicated next. We also have the applications submitted by Ukraine against Russia regarding Kerch Strait events in 2018 when Ukrainian vessels were captured, and there is a case of Ukraine against Russian Federation as to alleged practice of political assassinations of opponents to Russian regime. Russia submitted the application against Ukraine, but it was terminated in July this year because Russian Federation is deemed by the court as the state that does not have any relations with the court, and therefore the case is not adjudicated. So that's a very important stage for the consideration of the individual cases as the next step. But systemic nature of the issues that were identified by the court earlier due to the overall situation with the human rights in Ukraine and the issues related to the armed conflict need really well-coordinated efforts of Ukrainian authorities, the dialogue between European Court of Human Rights and Ukrainian judiciary. I believe that it is in need of a remedy in this situation with available remedies in Ukraine. And I believe that critically important for Ukraine is further improvement of the mechanism of constitutional complaint with the possibility of considering alleged violations of human rights after it completed the process of adjudication in general courts. That's the step that should be made, and the sooner Ukraine realizes that, the better it is. Let me stop here, and I hope that we'll have an opportunity for Q&A session. Thank you. Thank you, Mr. Hnatovsky, for really very interesting information and a very interesting presentation and your expert opinion. I just remembered one statement at the beginning of your presentation that has a deep sense. Human rights is something the government defends itself for, and that's indeed so. The human rights is the highest social value, and when we talk about national identity, sovereignty, and territorial integrity, the basis for all of this is surely human rights, their protection and enforcement. Dear participants, you are invited to raise your questions. Dmytro Gudima. Good morning. Thanks a lot for your presentation. Happy to see you. Given the types of cases we have in Ukraine, here is my question. Is there a case in the European Court that deal with the violation of their ownership right due to the mobilization of assets? We call them cases about mobilized assets. That's a popular issue for Ukrainian courts, whether that's movable or immovable property. Do you have this type of cases before the European Court of Human Rights? Thank you. Thank you. I'm happy to see you. Sorry that I couldn't make it to Lviv this time. When it comes to the cases on property rights, given the war, are quite numerous before the court, and I think next year we'll have them considered, and thus will have the position of the court with respect to these issues. I didn't happen to work with this group of cases yet, but if you have them, so there is a big likelihood that we'll get them too. Thank you. Any other questions, please? You quoted the number of 900 of individual applications and 6,000 plus that were made before, and this number is likely to increase given the events in the country. So what are the rights that are most frequently covered by these cases? So there are many cases linked to the right to ownership. That's assets that were ruined or damaged as a result of hostilities. There are many cases like that. There are cases with alleged violations of Article 2 and 3 of the Convention, many of them. There are applications regarding arbitrary detention of people, so that's a deprivation of freedom without grounds under Article 5 of European Convention. There are applications regarding the right to a fair trial, Article 6, many of them.
Є категорія, умовно можна назвати хлібік, так? Тобто ситуації, коли нормальна робота.
Let's say one of the cases, it's the Hlebic case when the normal operation of judicial system was hampered because the courts remained on the occupied territory and the appeal was not possible. Some other cases related to freedom to transport people who had been detained were penitentiary facilities, the transportation from the occupied territory to the territory of the occupier. There are various scenarios of this case. So, yes, indeed, we do have cases related to the right to private life. Some complaints deal with the freedom of expression. So the spectrum is quite high, but most massive kind of complaints are about property and disappearance of the people or arbitrary detention. Thank you, Mikola. That clearly shows that we certainly need a better mechanism to protect people against unlawful actions. Please, Irina, your question. Good morning. In fact, it's not my question. It's a question from the participants of our webinar. So, in general, this is can we expect that the war will impact the interpretation of some cases by European Court, in particular cases related to freedom of speech in the light of propaganda? I mean, the war as such, will it have any impact at such a large scale? Should we expect any changes in approaches by European Court? Thank you indeed. See, here the case is, the situation is that the guarantees provided by European Convention and case law of the European Court with regard to freedom of expression certainly are conditioned or restricted by some measures undertaken by the government if such restrictions are needed in democratic society. I don't expect any change of approaches, but to some extent I could remind you about the famous tests for Article 10. So what kind of, what deal of attention should be paid by the court to say the matters of security? You can, for instance, look at a decision delivered by the court in summer of the current year, and it was in case Gaponiuk versus Latvia. The story was about criminal prosecution of a political activist of the Russian community in Latvia for his statements in official networks, which actually were calling the Latvian government Nazi regime. That's armed intervention of Russian Federation is required to defend the people, where the court deemed this complaint unacceptable. But that's very delicate matter, and I wouldn't say that the court will always say that in the case of war there is no space for freedom of speech, etc. So it will depend on each specific case. So certainly we need to really consider the respective balance as required by the convention. Thank you. And another question from Sergei Kukhanenko. Good morning. I have another question generated by the war is related to migration situation inside the country, which certainly is caused by the warfare. And there is some governmental regulation, there are some governmental regulations in place, but they cause quite serious debates. And already there is a number of judgments related to crossing the border and the responsibility of the respective authorities that ban or prevent some categories of Ukrainian citizens, I mean, prevent from crossing the border. They prohibit such crossing. So I would get back to these three component test because it's about the law that allows for the border guards to deliver or to make these disputed decisions. And that's because we don't have any single regulation in light of Article Constitution 33 of Ukraine. There is no regulation which would allow for such prohibition and closing the border. Do you think that national courts should find their position, their standing with regard to the national legislation, which I would call exclusively the law, or maybe the way would be to interpret legislation as laws and other legal acts? I'm saying that because in this area, Article 33 of the Constitution is quite severe with regard to the article of the Convention that defines any other law, which that's Article 2, Protocol 4, and Article 33. The balance needs to be struck, but here the Article 33 of Constitution would prevail. Thank you. Thank you for your question. Indeed, this problem exists. I will not make any comments on the merit, but it was quite recently that we as the court communicated with regard to complaint Konichenko versus Ukraine. It was communicated on October 30th of the current year. The issues raised there were exactly what you described, and I recommend you to read this communication, and we will be looking forward into receiving comments from the parties. And also, we will help that this communication will be interpreted in the right way by Ukrainian government. Thank you, Mr. Mikola, for very interesting opinions. And I hope soon we'll see you, we'll welcome you here at the premises of our university. We'll be happy to see you. And in the end of your speech, you mentioned the need to further develop the institution of constitutional complaint in Ukraine. And due to some, the situation is that the next speech deals exactly with this subject matter. PhD in law of Lviv University, pro-rector of Lviv University, Mr. Sergei Reznik. Thank you indeed for the floor. That's for the second time. Indeed, I'm wearing two hats right now. It's a big honor for me. I represent the university administration and as professor of the Sub-Department of Constitutional Law. And, the dean is not a narrow expert in the case law of Constitutional Court, but for any lawyer, it's very important to have a certain understanding in this area. So I'll try within my time frame to mention some aspects of these problems, and I'll try also to react to quite interesting reservations, quite fair reservations that we heard here already. I can see further speeches, and I understand I will be quite close to the subject matter too. So, in Ukraine, there is very popular discussion in our media and in specialist media. It's about constitutionality of certain legal acts, conventionality and lawfulness of such legal acts. So if I manage to, I will try to split it into certain layers. Ukraine has been in this discussion for quite a long time at the level of interaction between constitution and international law about whether such acts, national level legal acts can be declared non-constitutional if they contradict to the international law acts. So it's clear that if we read the Constitution in contrast to a number of other states, this is a possibility does not exist. The Constitutional Court of Ukraine, in contrast to other states, is not vested with these competence. But maybe we should approach this issue not from the formalistic way, but looking into principles of international law established by both convention and constitution, so that they become criteria for assessing constitutionality of the acts. And here I will not tell you anything new, because it's just about structuring the proper methodology in respect to the principles and values of international order. The Constitutional Court of Ukraine yet in 2018 made very clear statement about the need to take into consideration the provisions of the international agreements ratified by Ukrainian Parliament in the light of how these provisions are applied and used by international institutions, including European Court of Human Rights. That was how the Constitutional Court of Ukraine initiated this so-called friendly attitude to the international law. There are many who interpret this concept in different ways. Some do not recognize it. Even the court was criticized by some of the justices, like, for instance, I quote, that the court derogated from their own standing with regard to friendly attitude to international law, which would be rather interpreted as attitude to the Constitution, which is friendly to the international law. This is about embodying the principle of international law by which the country should comply with its obligations. But in this case, the court reversed all that, speaking about creating the way that creates tension between the law and international obligations of Ukraine. This is discussion which is still on among the justices of Constitutional Court. So it's about the limitation between assessment of legal acts with regard to their constitutionality, and there was a dissenting opinion of a justice. These thoughts are often repeated, according to which the use of exclusively case law of European Court to substantiate non-constitutionality of specific law is wrong, because the standing of European Court cannot be the only criteria to assess the national legislation. Constitutional control requires the interpretation of the Constitution of Ukraine provided by the Constitutional Court, first of all. Mikola mentioned that, not only him, and I'd like to stress on that there is standing of European Court in this regard. They characterized the European Convention number of times as constitutional instrument of European public order. In one of the first judgments, the court stated the system of protection of human rights provided by the Convention is subsidiary, and it was mentioned thus the protection of rights and freedoms should be ensured by national authorities, first of all, judicial authorities. So what I'm trying to say that in general, in Ukraine, when we were approving Constitution in 1996, we had something similar to what Brits did in 1998 when they approved the Act on Human Rights, by which they implemented the Convention provisions into their national legislation. Now in the United Kingdom, they have the Supreme Court, and they deliver some judgments about non-constitutionality or non-conventionality of those acts that fail to meet actually this implemented provisions. So if we read Section 2 of the Constitution, as fundamental law, I mean rights and freedoms, human rights and freedoms, depicts to a large extent provisions of the Convention, thus eliminating the problem of constitutionality or conventionality, because if any legal act fails to correspond to Convention, automatically fails to correspond to the Constitution. That does not mean that a European Court judgment will always and necessarily be exact and accurate, but my first statement, non-conventionality means non-constitutionality, it still works. There have been no judgments stating the opposite, but I like to say that in different European countries, constitutional courts have different case law. Like Spanish Constitutional Court stated, judgment by European Court have merely declarative nature and are not applicable in the legal space of Spain. But still, they imposed on the national authorities the obligation to consider the judgments delivered by European Court. But we know quite different position taken by Belgium Constitutional Court or Supreme Courts, which have also constitutional jurisdiction in some countries. So if we talk here about some summary of this first part of the speech, I'd like to emphasize that constitutionality and conventionality is a problem within constitutional law of the country needs a solution, but that means that our policy in education, in scientific research, certainly we need to continue communication with this regard, and it's very important, especially from the point of view of examining the case law of European Court.
Конституційності нормативних актів. які стосуються
Constitutional Court cannot decide on the constitutional acts that deal with the violation of the human rights, and there is a clear position of the European Court on that. I think that's the way for us to proceed, and I am happy that we have a human rights lab at Lviv University, and we were the first to introduce the constitutional values course at the university to make sure that the students get this knowledge during their first year of study. I'm happy that we have this type of fora organized in Lviv University. We'll be happy to answer questions. Thank you, Serhiy. Official constitutional doctrine of Ukraine should be shaped under European standards, conventional values, and the dialogue in the judiciary should be part of it too. When we are officially on the path to European integration, that requires a special importance. Now we have Q&A session. Any questions to the presenter? Irina? That's about the compensation of damage caused by unconstitutional law. So you mentioned unconstitutional acts, how to compensate for damage. Article 41, that's the one that correlates with the European Court. We believe, or some experts believe, that we don't have any legislation that could give rise to legitimate expectation to tangible compensation. Others say that we can take civil code, and compensation of damage is nothing new there. So how would you comment on that? Should we adopt a separate law on that? And if yes, what should it cover? Because compensating everybody for everything, if it is damage caused by unconstitutional law, that's a lot to compensate for. Thanks a lot for your question. I would add the following. The Constitution provides for compensation by unlawful decisions of the government, and civil code is supportive here, but that's a long-standing issue. We have a number of provisions, and one of them is something that has not been fully implemented, and since 2016 we had expectation that through the mechanism of constitutional complaint, this mechanism could be resolved. But it is still pending. There is a number of judges, and some of them might be present here, who are sure that this right should be realized in some way. But again, these judges are a minority, and today the opinion that is prevailing is not quite law-based, but it is based on the concept that democracy should be able to protect itself. And if you open this Pandora box, then how the government can financially cope with that? So that's one of the arguments of this group of experts. And again, the decisions of the Constitutional Court that are reversible time-wise, and there is only one argument of those lawyers that say that it is impossible that the budget won't be able to cope with that. But that's a very complex philosophical and legal issue, and we needed to sort of, meet in the middle between these two opposite opinions. I am a supporter of a compromise, and both the first and the second should be implemented. Serhiy? It's not really a question, but just a follow-up to what you were saying. I am one of those that, on the one hand, looks at the direct provision of the Constitution, the impossibility of refusing due to lack of legal act, and procedural codes clearly speak about that, and diversity of case law as to the solution of these disputes. We have the position of the Grand Chamber, and we also have the opinion of the Cassation Civil Court as to lack of violation of Article 1, Protocol 1 to the Convention. And what I'm concerned about here is the following. The existing judgments of the European Court, including the ones regarding the civil code provisions dealing with the compensation of damage and finding unlawful some legal acts, says that it's not governed by the law, and that's an issue. Unfortunately, I don't see that lawmaker is willing to fix it, and given the war in the country, I don't think it will happen shortly, because we know the limits of the public budget, and we know how dependent we are on our partners. Thanks to the support of our partners, we are able to exist today, but at the same time, we needed to find some balance. Where is this balance? Human rights, that's something we fight for now, defending our country, and those capacities of budget that the government has. If the court starts handling this vis-a-vis direct force of the norm, and then that would prevail over the capacity of the budget. So I agree that we need a clear position of a lawmaker to this end. Otherwise, the situation with social benefits could deadlock. That's a really serious issue, and we know that none of the constitutional provisions of direct effect cannot be interpreted in the manner that eventually would lead to the destruction of the state. That's a very important element, and we have to keep that in mind when talking about this balance. Noel Calhoun.
I wanted to ask, when we're seeing Ukrainian legislation is being adopted, it's a normal part of the process that the apparatus of the Verkhovna Rada will conduct this analysis of draft legislation to look at, which is supposed to look at its whether it complies with international obligations. What we've observed in the past months is that frequently when it is analyzing legislation that is related to the war and related to exceptional measures that are being adopted in relation to martial law, that there is no analysis of the necessity and proportionality of the measures being considered. And so this is not a part of the regular work of the apparatus, it seems, of the Verkhovna Rada, which leads to certain laws being adopted where there may be reasons, there may be valid justifications and in line with European and international obligations to adopt these time-bound measures. But if there is no explanation, if there is no analysis, it's very difficult when you're coming from an international organization to say, well, does this comply with international law or it doesn't comply, because simply the Ukrainian lawmakers have not provided that sort of analysis. So I guess my question is what can be done about that?
Дуже дякую. Насправді я згоден з
Thanks a lot. I fully agree with you that there is an issue like that. And again, we look at it from the point of view of constitutional dimension, and we see it as lack of constitutional self-control. You can draw analogy with the compliance of the legislation with international law. There are several angles here. The first one is sometimes the parliament does this assessment in a very effective manner. I've seen several instances when there is an opinion of a legal department and respective committees of the parliament express their position, and the position of the NGOs were taken into account. But there are instances when it doesn't happen, and that's because whether the legal department is not working productively, or the opinion of legal department is really powerful, analysis has been conducted, but whether the committee or at the session the position of the legal department is not taken into consideration. So we need to work jointly at all levels, whether these are students or members of the parliament, to make sure that this work is done, so that courts have less work then. If this legislation is subjected to assessment, then it would not be referred to potentially the Constitutional Court, or would lead to the analysis given the violations of human rights. Because now when we look at the cases, we see that until the decision is delivered by the court, irreversible consequences are already there, and we face the issue similar to what Irina raised. The damage cannot be compensated, irreversibility nature of the decision cannot be applied, or the compensation that is awarded is unproportionate to the damage caused. So we need to work through interaction, through cooperation, and we shouldn't believe that the courts are the only ones that can resolve the issues. We should have to start working from the university level to make sure that the solutions are found. Thank you. There are some other questions. Yes, please. Sometimes a constitutional court finds unconstitutional a provision, but then resorts to the following mechanism. This provision loses its force as 6 months the Constitutional Court delivered respective decision. So the Constitutional Court found the norm unconstitutional, but states that for some time this provision will govern public relations. So from your perspective, what's the purpose of the use of these tools by the constitutional body? Taking the sentiment that I caught when you asked this question, you are not supportive of that. No, it's just interesting because it was stated that the provision is not constitutional, but at the same time we say, okay, so let this provision govern the relations for 6 months or so, and then we'll deal with the effects. I do agree that there is an issue like that, and it goes back or it is linked with other legislative provisions, because the decision of the Constitutional Court finding the provision unconstitutional leads to the fact that this provision should lose the effect rather than just keep this provision in any wording. Let's say there was a pension of 5,000 hryvnia that should have been awarded, but it was paid 10. So if the provision was found unconstitutional, it doesn't mean that both 5 and 10 should be abolished. It seems to me that the Constitutional Court tried to maintain some balance and not to cause any more serious damage by finding this provision unconstitutional. So if I were a Constitutional Court, and they seldom do that. In these instances, I would immediately point out to the Parliament, though it's not binding to them, to make sure that the Parliament will bring in compliance of the legislation with the Constitutional Court decision without waiting for 6 months or so when the decision comes into effect. I agree that there is a tool. I agree that there is an issue about this tool, but this tool shouldn't be abused. It seems to me that when this mechanism was introduced, it was more or less balanced, but we need to pursue a comprehensive approach when finding solution to this issue. And there is another question, Dmytro. Thanks for an interesting presentation and the focus of the presentation. Let me go back to what Mykola was saying. He said that Ukraine is to pay more attention to the mechanism of a constitutional complaint, and that was linked to the number of applications before the European Court against Ukraine. What do you think about introducing the mechanism in Ukraine whereby the constitutional complaint should be mandatory before application to the European Court if the case deals with the alleged unconstitutionality of provision? Is it possible to make it mandatory so that application to the Constitutional Court would be mandatory before going to the European Court if we are talking about unconstitutionality in the case? Is there any link to this? I mean, and could it be a kind of a filter before applying to European Court? Thank you, Dmytro. The issue is very interesting with the very beginning of introducing constitutional complaint model in Ukraine. That's our model, and it has been subject of the discussion since then. Everybody agrees that in the way it exists, this submission to the Constitutional Court is not mandatory. Getting back to your question, let me just tell a few words about why we are talking about this issue. We have a unique model of constitutional complaint that's unique in the world. At least in Europe, there is nothing similar when the object of constitutional control is just the law. We are talking about constitutional complaint mechanism. When it comes to other legislation, so they are not subject to constitutional control, and that creates the first issue. On the contrary, in the constitutional courts of other countries, the laws are not subject to constitutional complaint. So that's something that other subjects pay attention to. So therefore, we need a comprehensive reform of the constitutional complaint mechanism or institution. And it seems to me that it didn't work well in Ukraine. And even those groups of cases that are considered, and nothing to say that 80% of them deal with the same group of pensions. So I'm sure that if we talk about constitutionality of legal act, and if it is the core of the application to the European Court, then this type of a filter could be introduced. I am a supporter of that, but again, this filter would decrease the number of applications to European Court by 20–30% at least.
Потрібна конституційна реформа. І дай Бог, щоб
So I'm fully supportive to this idea, but we will need constitutional reform because we all as academia should support and as researchers should support this reform rather than creating the fourth instance in the judicial system, but we should narrow the subject matter to the question of constitutionality of legal acts. Thank you, colleagues, for fruitful discussion. We're getting back to our agenda. we introduce some changes. We still have 2 speeches, and it looks like we're certainly working within our time frame. Ivan Yelich, representative Chernogoria in the European Court, who will speak about correlation between the international law and national law of human rights. She will speak online.
Hello, everybody.
Good afternoon. Hello.
Hello.
We are welcome you.
I greet you from Strasbourg, and I'm sending the best regards from this foggy city of a human rights protection in Europe. Thanks to my colleague, Judge Gniatowski, and to the organizers, I'm invited to speak today about the interaction between international humanitarian law and the human rights law. And I would like to put emphasis in the case, go on the case law of the European Court of Human Rights in this context. So I will take 20 minutes to talk to you. I'm very sorry that I was unable to join you in Lviv, but I hope that there will be opportunities in future. So during the 53rd session of the Human Rights Council, the UN High Commissioner on Human Rights, Volker Turk, noted that the Russian Federation's senseless war in Ukraine continues to generate severe and far-reaching violations of human rights and called for just peace. This statement, clearly linking the protection of human rights with peace, finds to a certain extent an echo in the preamble of the European Convention on Human Rights, in which it is stated that the fundamental freedoms and the foundation of justice and peace in the world. Having that said, the notion of human rights and peace seem at first sight to belong to 2 different languages, namely the language of the human rights law and the language of international humanitarian law. Interminable discussions have been held to distinguish those 2 fields of international law, some highlighting the similarities between international humanitarian law and human rights law, others on the opposite emphasizing the differences. While both have a humanitarian character and a human rights character, and seek to preserve the dignity of human beings, which is the material source of all human rights, in the context of war, armed conflict, and in the context of a peace. International humanitarian law is mainly tailored to military necessity and the principles of humanity. It is based not on the rights, but on the obligations of the parties to a conflict, and the rules applicable to an individual depend on his or her status as a member of a group, combatant or civilian. Needless to say, nowhere does the European Convention on Human Rights refer directly to international humanitarian law, although the latter field of international public law may be indirectly targeted in Article 7 of the Convention. The case of application by the Court of International Humanitarian Law within the framework of the Article 7 of the Convention is quite specific and will not be assessed further in this presentation, but I would like to draw your attention to Korbli versus Hungary and Konovo versus Latvia for this reference. And also Article 15 of the Convention, which allows a state party to derogate from its obligations under the Convention, provided that such measure is not inconsistent with its other obligations under international law. Whilst there has been a considerable number of applications to the Strasbourg Court arising from situations of armed conflict, There are, in fact, relatively few in which the court has had to consider the applications of international humanitarian law and its relationship to the European Convention on Human Rights. Here I would like to say that the relevant document is the report of the Steering Committee of the Human Rights, CDDH, report on the place of European Convention on Human Rights and in European and international legal order, which is from 2019. How does the European Court of Human Rights conceive the interplay between international humanitarian law and human rights law is how I understood my today's task. So the recognition of the applicability of the European Convention on Human Rights in situations of armed conflict, no matter if it is international or non-international armed conflict, is actually connected to the interpretation by the European Court of Human Rights and its engagement with international humanitarian law, which relies on the recognition of the applicability of the Convention in these situations. Referring to the case law of International Court of Justice, which we cannot avoid when we talk about this context, the court in Strasbourg indicated in the judgment Hassan versus United Kingdom, and more recently in judgment Georgia versus Russia number 2, that, and this is quotation, even in the situations of international armed conflict, the safeguards under the Convention continue to apply. The provisions of the European Convention on Human Rights continue thus to apply irrespective of the situation, both in times of peace and in times of war. The battlefield is no longer the exclusive domain of international humanitarian law. In fact, by recognizing the applicability of the Convention in situations of armed conflict, the court simply aligns itself with other international courts and tribunals and non-judicial human rights organs. The International Court of Justice has thus stated in its advisory opinion on the legality of the treat and use of nuclear weapons, and in its advisory opinion on the construction of a wall in the occupied Palestinian territory, that the protection offered by human rights conventions, such as the International Covenant on Civil and Political Rights, does not cease in case of armed conflicts. Similar solutions have been adopted by the UN Human Rights Committee, for example, in the General Comment number 36 on the right to life under Article 6 of the ICCPR. By the UN Human Rights Committee of the Elimination of Discrimination Against Women, CEDAW, and in its General Recommendation number 30 on women in conflict prevention, conflict and post-conflict situations. And also in Inter-American Court of Human Rights, which held in the judgment Las Palmaros versus Colombia, that it is competent to determine the compatibility of an act with American Convention on Human Rights in times of peace or armed conflicts. This applicability of human rights law in situations of armed conflict is, however, not without limits. On one hand, the derogation clause under Article 15 of the Convention, which will be further analyzed at a later stage, allows to set aside the applicability of human rights law in situations of armed conflict. Indeed, this provision of the Convention, echoing the solutions adopted in other international treaties, indicates that state parties cannot derogate from their obligations to secure certain rights and freedoms under the Convention in times of war or other public emergency threatening the life of the nation. On the other hand, the court has also at its disposal tools such as the concept of jurisdiction under Article 1 of the Convention that allow it to put aside the protection of European Convention on Human Rights in situations of armed conflict. In that regard, in the judgment Georgia versus Russia number 2 concerning the 2008 international armed conflict between Georgia and the Russian Federation, the court ruled in a highly controversial manner that it could not apply in respect of Russia either the spatial model of jurisdiction, control over territory, or the personal model, authority or control over the victim by a state agent, for the purpose of assessing the lawfulness of the kinetic uses of force, such as artillery shelling during the active phase of the conflict. by refusing to recognize the jurisdiction of Russia in the present case, the court created a vacuum imperfectly filled by international humanitarian law. In this judgment, the court quite contradicts the principle of coexistence of human rights law and international humanitarian law. There is this statement that this does not mean that the states can act outside of the legal framework. They are obliged to comply with the very detailed rules of international humanitarian law in such context. And this is the paragraph 143 of this judgment. Exit the human rights protection offered by the European Convention on Human Rights, the victims have to make with the rules of international humanitarian law. Through this case law, the court digs a ditch between human rights law and international humanitarian law, which seem to be suitable enough to address alone the issues related to armed conflicts. The recognition and the co-applicability of the European Convention on Human Rights and international humanitarian law could be described by recognizing the applicability of the Convention in situations of armed conflict, that the court has paved the way to the recognition of co-applicability. And this indeed happened when the court ruled that in situations of armed conflict, provisions of the Convention ought to be interpreted in the light of the rules and standards of international humanitarian law. Let me remind you that even in non-international conflicts, Article 3 of the Geneva Conventions, Common Article 3, is applicable, and there we have a set of non-derogable human rights which could not be derogated even in the times of a armed conflict. And here we have this core circle of human rights that are both non-derogable under the Convention and under the Article 3 of Geneva Conventions. Until 2009, Judgment Varnava and others versus Turkey, the influence of international humanitarian law on the European Convention on Human Rights was largely unspoken and implied. The court was interpreting the provisions of the Convention in light of international humanitarian law without expressly naming this latter field of international public law. For example, in the judgment Ergi versus Turkey and Ahmet Özkan and others versus Turkey, both concerning non-international armed conflict between Turkish security forces and members of PKK, Kurdistan Workers' Party, the court made a distinction between the lives of combatants and those of the civilians population under the interference of international humanitarian law, in particular Articles 50, 51, 57, paragraph 1 and 58 of Protocol 1 to the Geneva Conventions, and Article 13 of the Protocol 2 of the Geneva Conventions. And rightly highlighted in the interesting joint partly dissenting opinion by Ukrainian Judge Yutkivska, former judge at the time, Pinto di Albuquerque and Chanturia, under the judgment in Georgia versus Russia. And here I'm talking about paragraph 3 of this opinion. Having that said, an express reference to international humanitarian law is nowhere to be found in the judgment. The court can thus take into account rules and standards of international humanitarian law and interpret the provisions of the Convention against this background without, however, mentioning expressly the introduction of a foreign element in its assessment. The judgment Varnava and others versus Turkey involves a breakthrough in the acknowledgement of the influence of IHL in cases related to situations of armed conflict and in the determination of the way the Strasbourg Court conceives the place and role of the field of international law in its reasoning. Indeed, in the judgment, the Strasbourg Court held Article 2 must be interpreted insofar as possible in light of the general principles of international law, including the rules of international humanitarian law, which plays an indispensable and universally accepted role in mitigating inhumanity of the armed conflicts. And here I call into the paragraph 185 of Varnava and others versus Turkey. In that regard, the court follows the stipulations in Vienna Convention on the Law of Treaties and its famous Article 31, paragraph 3c, which states that the treaty shall be interpreted by taking into account any relevant rules of international law applicable in the relations between the parties. Revealing its openness to exterior sources of international law, the court in Strasbourg positions the European Convention in the web of international rules and standards. In the mentioned judgment, the wording, insofar as possible, suggests that the interpretation of the Convention provisions in light of international humanitarian law is not limitless. The court seems, however, to approach this caveat lightly, shrugging it off when needed. The exact meaning and the scope of the limitation seem quite unclear. Indeed, in the judgment Hassan versus United Kingdom, which shall be analyzed maybe more, but we have a limited time today, the interpretation of Article 5 of the Convention in light of the provisions of international humanitarian law, or to paraphrase the court, the accommodation of Article 5 of the Convention with the provisions of IHL leads to the adoption of a solution which clearly contravenes Article 5 of the European Convention on Human Rights. Interpreted in the light of international humanitarian law, the provision of the Convention is stripped of its content to the extent that it even seems difficult to speak about a co-application of the human rights law and international humanitarian law in the present case. By recognizing the co-applicability of IHL and the human rights law in situations of armed conflict, the court enters a foreign territory. Indeed, such a recognition implies that the European Court needs to interpret and determine the content and the scope of rules and the standards of IHL. Undoubtedly, this is not a task for which it has not been originally created. To evaluate whether international humanitarian law is applicable in a particular case, in concreto, the court has to characterize the facts according to IHL. In the judgments Savribikian and Balayan versus Azerbaijan, the court highlighted thus that for international humanitarian law to apply, there must normally be an armed conflict or occupation of a territory. And here I'm talking about quotation from paragraph 38 of the judgment. And subsequently, conducted an analysis whether the hostilities and tensions between Azerbaijan and Armenia constituted an armed conflict or an occupation of territory within the meaning of IHL, in particular Article 2, common to 4 Geneva Conventions. In the judgment Georgia versus Russia, number 2, the court held somewhat rapidly that here you have interesting article from Marko Milanovic, and I could share some references with you later on if you would be interested. But it is interesting that the court held that the concept of occupation for the purposes of IHL includes a requirement of effective control. If there is occupation for the purposes of the IHL to be applied, there will be also the effective control within the meaning of the court's case law, although the term effective control is broader. It is interesting to note that in the judgment Bankovic and others versus Belgium, the court used the Geneva Conventions to argue that if the drafters of the convention, European Convention, had wanted to grant jurisdiction that was a far-reaching and that proposed by the applicants, that then they could have adopted a wording that was the same and the similar of Article 1 of 4 Geneva Convention, which requires the contracting parties to respect and ensure respect for the conventions in all circumstances. This obituary remark included by the court in the judgment reveals an attempt to harmonize and systematize the relationship between European Convention on Human Rights and IHL. What is the influence of IHL on the protection accorded under the European Convention in situations of armed conflict could be seen through defining the role of international humanitarian law in the adaptation of the Convention protection in situations of armed conflicts or wars, and what are challenging in this context, what is challenging in this context of adoption of the Convention protection in situations of armed conflict through a co-application of IHL. I think here we have relevant case law, namely Georgia versus Russia, that European Court of Human Rights held that the ill treatment inflicted on the Georgian prisoners of war caused severe pain and suffering and must be regarded as acts of torture within the meaning of Article 3 of the Convention. Those acts are particularly serious given that they were perpetrated against prisoners of war who have a special protected status under international humanitarian law. So I quoted the paragraph 278 of this judgment. Having in mind our limited time, I'm not going to continue. I already breached 2 or 3 minutes. Sorry for that. But I really had a complex question, complex issue to address because the interaction between IHL and human rights law under the Convention remains largely open, in my opinion, despite the readiness of the Strasbourg Court to apply and implicitly accept co-application in the cases that, in concrete cases that are applicable or suitable for that approach. Once again, I would like to thank you for your attention and to wish you a successful conference and all the best to dear Ukraine.
Дякуємо, пана Івана, за цікаві думки.
Thanks, Ivana, for interesting input and raising practical issues of application of international humanitarian law and human rights law, given practical issues we are facing when we needed to identify which law is to be applied and to which extent. Anyways, they are complementing each other and should reinforce each other. Dear participants of this forum, you are invited to ask questions. Good afternoon. Did I get you right, Ivana? The defining element to apply international humanitarian law norms for European Court is to determine whether armed conflict, international, non-international, took place or not. That's the first question. So, to apply the international humanitarian law provisions in the case law of European Court. And the second question, if it is evident that there was no international armed conflict, but it was internal turmoil, is there any practice that your European Court used some guarantees of international humanitarian law, or given adversariety, it took into consideration the interests of the state and conditions, and could have said that, let's say, allegedly the state did not violate any guarantees or human rights of an individual.
So I tried without interpretation because our languages are similar. My Montenegrin and Ukrainian could be used just, but not in a profession. So I turned to interpretation. According to our case law that I quoted, the existence of armed conflict or occupied territory so far is actually needed. But as I said, this is the situation in every case in concreto has to be assessed, and there is this evident openness of interaction between IHL and the convention. Wherever, I would say, this is my personal interpretation, wherever there is this overlapping in terms of the core rights, non-derogable rights, which are Article 2, 3, 4, and then ne bis in idem, according to Article 15 of our convention, which are similar with Article 3 of both Geneva Conventions, which is totally different context, the context of war, plus, of course, taking hostages, which is also non-derogable in this context. Then we are talking about the application of the convention in situations, and we don't deal if it is international or non-international armed conflict. Of course, every situation has to be assessed in concreto, and we have, I would say, a limited case law so far. Conflicts that happened were not only desired but also expected, and the European Convention on Human Rights is applied in terms of a living instrument doctrine, which means in the present day's conditions. I cannot talk about the pending cases. I hope you understand this. That's why I only quoted, which could be quoted, respecting my mandate as an international judge. Thank you for your understanding.
Дякуємо, пані Івана, за те, що поділилися.
Thank you, Ivana. Thank you for sharing your expert opinion, and thank you for having found time to be with us and answer the questions that we have. Thanks a lot. Appreciate it. Dear colleagues, we move on, and the next presentation is going to be the concluding for this session. The one we are going to hear is proceedings in conflict-related criminal cases and their compliance with the international human rights law. And let me give the floor to the Deputy Head of the UN Human Rights Monitoring Mission in Ukraine, Noel Calhoun. Over to you. Thank you, Marta. At the beginning, Mr. Natovsky mentioned warm recollections of being here. Though I am for the first time here, I feel the sentiment. Thanks a lot for the invitation. I'll continue in English.
I'm going to talk today about judgments in conflict-related cases, criminal cases in light of international and European human rights standards. But first, let me say a couple of words about the organization I represent and how we work and how we come to the conclusions that I'll share today. We've been working in Ukraine since 2014. We document, monitor and document human rights violations and report on them on a quarterly basis to the Human Rights Council in Geneva. And our monitoring starts with the victim. or the person who's making a complaint about a human rights violation, such as defendants in criminal cases who say their rights have been violated. We conduct interviews with them frequently in pretrial detention facilities which are not as beautiful as this. We meet with lawyers, we review court submissions and judgments. In some cases, we also attend hearings. And you might ask, why do we focus on conflict-related criminal cases? In the first place, because these are very serious and sensitive cases like collaboration, cases like treason, and these sorts of difficult cases pose a test to any judicial system. And secondly, we focus on these cases because of what we hear from victims. Ukrainian victims of violations associated with this war want justice. And justice will only be served if the legal proceedings are fair and the decisions taken here in national courts will hold on appeal, including when reviewed by the European Court of Human Rights. So today I want to talk about three potentially problematic areas related to judgments in conflict-related cases. The first concerns the substantive criminal law, and the other two concern criminal procedure. The first is about substantive criminal law, and it's about Article 438 of the Criminal Code of Ukraine. As you know, this was an article that was written a long time ago. It's not something that's been introduced after the armed conflict. It is a blanket rule referring to the violations and rules and of the rules and customs of war, and it names a couple of specific violations, such as the cruel treatment of prisoners of wars or civilians. But then it also refers quite broadly to other violations of the laws and customs of war recognized by international instruments to which Ukraine is a party. So very broad. The wording of Article 438 may raise two concerns under the European Convention. The first is in relation to Article 6.3a, and that article requires that a person charged with a criminal offense is informed promptly in detail of the nature and the cause of the accusation against him. So to fulfill the requirements of this article, it's not enough simply to inform a person that he's been charged with committing a violation of the rules and customs of war. That's something very broad and big, or with a general reference to the Geneva Conventions, because the Geneva Conventions have a lot of violations in them. The article requires that the defendant is informed of the precise legal qualification of the alleged acts. And this is referred to in the case of Sedovic versus Italy. So in our monitoring of war crimes proceedings, we've observed that in many cases, the defendants were not informed in detail about the charges against them. In some cases, the charges did not make references to all of the elements of the violation that was allegedly committed. So another problematic issue with our Article 438 is its compliance with Article 7 of the Convention, which refers to no punishment without law. The principle of legality requires the clear definition of offenses and their corresponding penalties, and also requires certain qualitative requirements for the law, that it be accessible and foreseeable. So the question is whether Article 438, given its very broad language, has the qualities of law required by Article 7. On the one hand, you could say that, well, this is a very specific circumstance with Article 438. There are some specific factors. One is the flagrant nature of the offenses. These are war crimes. The second is the fact that persons charged with these crimes are military personnel who should have been trained on international humanitarian law, because teaching it is a requirement under the Geneva Conventions. So it's not entirely clear, but in some cases, we see that the definition of the crime is indeed clear, like in very straightforward cases like the killing of civilians. However, having read many verdicts in war crime cases, we see there are decisions in which there's less clarity, especially about the elements of the crime. A good example is on decisions in cases involving unlawful confinement of civilians. Those are cases in which often not all of the elements of that crime under IHL have been proven in the case. So they haven't even been laid out necessarily in the case. So we would, for this reason, suggest considering amendments to the criminal code to make the definitions more precise and to ensure the requirement of accessibility and foreseeability of law. So we think this would serve multiple, we think it would be a good idea to have a revised Article 438 with specific elements for each crime, such as what we see in the Rome Statute. And this would serve multiple purposes. It would ensure that the defendants, in the first place, the defendants would be informed in detail of the charges. This would comply with the requirements of accessibility and foreseeability. It would also help legal professionals to ensure that they are covering all of the elements of a crime when dealing with a particular case, and allow for better compilation of data on war crimes, distinguishing between different cases, different violations and victims. However, pending any changes to Article 438, courts can refer directly to the elements of war crimes as contained in international humanitarian law. So now I'd like to move on to a couple of procedural issues. And the first is the lack of alternatives for pretrial detention. In conflict-related criminal cases, defendants have limited scope to challenge the legality of their detention pending pretrial investigation and trial. This is because of the rules introduced to the Code of Criminal Procedure. It's Article 176.6 and Article 183. These provisions were introduced in early 2022 following the introduction of martial law. They provide that during martial law in conflict-related cases, there is only one preventive measure available, and that is pretrial detention. And that prevents the granting of bail in conflict-related cases. We have seen extensive application of pretrial detention in these cases. We analyzed 900 court rulings rendered between September 2022 and January 23, and found that courts remanded defendants in custody in all but 30 cases. The widespread use of pretrial detention in these cases can create pressure on individuals to testify and to plead guilty. Earlier this month, we see that the Constitutional Court has commenced proceedings related to the clause that prevents the granting of bail. And it's not the first time that the Constitutional Court is considering a similar issue. In September 2019, the Constitutional Court considered the legality of a rule whereby defendants in conflict-related cases were remanded in custody without courts having considered the necessity of detention or alternative preventive measures. The court found then that the rule was unconstitutional, and it quashed it because it limited judicial control of detention and interfered with the individual's right to liberty. The Constitutional Court in this case also referred to the jurisprudence of the European Court of Human Rights, to Harchenko versus Ukraine and Khaireddinov versus Ukraine, where the European Court found a violation of Article 5 of the Convention because the national courts did not consider alternatives to pretrial detention. So our hope is that lawmakers will change this clause, creating greater opportunity for defendants in conflict-related cases to apply for bail, or that the Constitutional Court will make this decision in the interests of fair trial rights. Finally, I would like to discuss trials in absentia. The majority of war crimes are cases in absentia without the defendants being present in court. Having followed many of these cases, we've identified three concerns about this. First, under international human rights law, accused persons have the right to be present in court during the trial. And so this is why absentia proceedings are exceptional, and they have to meet certain conditions. including the possibility of retrial once the defendant has been located. However, in Ukrainian law, that right to retrial is possible only if the defendant is located before the court delivers its verdict. Once the verdict is delivered, it is final, and the defendant is not entitled to a retrial. Second, it is nearly impossible for defense lawyers to deliver effective counsel in trials that are held in absentia. Ukrainian law says that defense lawyers must not act against the will of their defendants, which implies that they coordinate with their defendants. In the absence of that contact, what we've seen is that defense lawyers usually remain inactive. For example, when we read court decisions and read about what have the defense counsels done in cases where the trial is held in absentia, we read references like this. The defense counsel had no opportunity to contact the accused and find out his legal position on the charges. Or, another example, the defense counsel relied on the discretion of the court to assess the deeds of the accused and their legal qualification. The European Court has repeatedly stressed that, and I quote, although not absolute, the right of everyone charged with a criminal offense to be effectively defended by a lawyer, assigned officially if need be, is one of the fundamental features of a fair trial. A person charged with a criminal offense does not lose the benefit of this remedy merely on account of not being present at the trial. And lastly, the notification of the defendant about the trial is the most tricky issue. The UN Human Rights Committee concluded that a state's failure to take appropriate steps to notify the accused is a breach of the right to a fair trial. And the European Court has gone even further on this in Sedovic versus Italy, saying that courts cannot infer that a defendant has waived his right to appear at trial, even supposing that the applicant was indirectly aware of the criminal proceedings. The lawmakers can solve some of these problems, such as allowing for retrial once defendants are found and strengthening the procedural requirements for notification. In the meantime, it would be appropriate to avoid holding trials of defendants who are not duly notified. Why is this important? It is possible that Ukraine will in future face multiple complaints to the European Court submitted by persons who were tried in absentia. Without strict adherence to fair trial standards, verdicts in these cases will be at risk of being deemed violations. Other states may also refuse to extradite defendants convicted in absentia because the proceedings did not comply with international standards. This would prevent the enforcement of verdicts and hamper victims' right to an effective remedy. So I thank you again for the opportunity to share these thoughts and for the discussion. Thank you.
Дякую щиро, пані Ноель. Дійсно, кримінальні провадження це
Thank you, Noel. Indeed, criminal proceedings is the area where the violation of human rights are quite possible, and now, especially in the wartime, they may have massive nature, and certainly we will have to look for additional legal mechanisms.
Clients who can be very unpopular. So this is a very difficult area of law.
Так, і початок війни, введення воєнного стану, вони дійсно зумовили...
Yes, indeed, an introduction of this martial law actually stipulated for some changes in the criminal code and code of criminal procedure, and without any doubts, we need to think to what extent they meet international human rights standards. So now we are drafting the new criminal code, having some new approaches and models, so we hope that the legislators will take into consideration all these elements. Colleagues, you're invited to the discussion and to ask your questions. Thank you indeed for your speech. My question is as follows. You tackled with the fact that there is no choice for preventive measures, for measures of restraint for some defendants with respect to qualifications of their crimes. these amendments were actually called because of introduction of martial law in Ukraine, and they mostly apply to those who are charged of crimes against national security or crimes against humanity. And my question is that maybe it could be an exception. This approach could be linked to the derogation, as mentioned, derogation from Article 5, as Ukraine actually Ukraine referred to it with the beginning of the war, large scale.
I think the point is that this is a decision that should be taken in an individual manner based on the facts in the case. Certainly, in many cases, you were right that if the person's acts pose an ongoing threat to national security and are of a seriousness that risk exists, then it would be appropriate that the judge imposes pretrial detention. However, the seriousness of the crimes with which people are being accused range very broadly. There are people who are being charged for glorification of the aggressor state because of putting likes on Facebook. That these are for certain statements. So there should be a judgment in that case whether do these acts pose a significant threat, ongoing threat to national security, such that the person should be held in pretrial detention for these acts. So I think it goes, if this were defined very narrowly as just was about, say, treason, for example, then perhaps what you're saying would be logical, because these would be very serious crimes for which it was pretrial detention would be a suitable preventive measure. However, the range of crimes consists of many that are of different levels of seriousness, and so there is a question here of proportionality, and it seems that it would be best a decision taken on an individual level by a judge rather than to apply universally to everyone who's charged with this category of crimes.
Дякуємо. Ще в нас є бажаючі задати запитання, будь ласка.
We have more questions, please. I'd like to talk with the matter of legal aid, because when there are criminal proceedings for crimes of war, we often have to deal with exchange of prisoners of war. And what happens that the defendant for war crimes, the defendant has legal aid, and then the exchange takes place and this individual disappears. And when such defendant actually crosses the border, he stops taking any further measures. So this is the question about commensurability of the human rights and further proceedings, because initially this defendant had legal standing and communicated with his defense lawyer, but after the exchange, neither court nor defense lawyers have a chance to get in touch. So what should we do when an individual was at the trial, but then there was exchange?
We would start with the first point, that if there is an ongoing criminal investigation against a person for a war crime, it's a question why that person should be exchanged. It would make more sense that the trial be completed, and then the person would be subject to exchange after the criminal proceedings have been completed. so I think that would be the first question is why is the exchange taking place ahead of the criminal proceedings? Because if there is an interest in justice and accountability, then the judicial proceedings should take priority. So then, if I understand correctly, the question is if the criminal proceedings have started and the person has a lawyer, then at least we have the issue of notification has been addressed. The person has been duly informed that there are criminal proceedings instituted against him, and that he has had some opportunity to communicate with his legal counsel. So that from that point forward, then it would be the responsibility of the lawyer to maintain a contact with his client in order to be able to provide effective counsel. However, I can see there would be many possible complications, such as what happens if the person changes the lawyer or the lawyer stops providing that counsel. So to me, it seems we seem to have fewer problems in cases where the criminal proceedings are instituted while the person is in Ukraine and the person is duly informed of the proceedings against him.
Дякуємо, пані Ноель. Маємо ще запитання.
So can I have another question? Good afternoon. I'd like still to get back to 438, Article 438 that you started with, and I participated in many discussions where this article was mentioned. Nobody would ever say that it's an ideal article in our criminal code. Everyone calls that blanket provision. That's correct. It certainly needs to be changed. But there is a number of other questions, and I'd like to ask your opinion about one of them. But the question is when these changes should be implemented, right now while we're in the conflict, or later on, and in which way? Because this conflict actually started in 2014. It's been for 2 years that we have large-scale invasion. We have more than 2,000 criminal proceedings. Some of indictments have already been submitted to the court, and the convictions took place with reference to Article 438 as it is now. If we amend it today or maybe in a month, the conflict continues, and then probably the elements of this crime will change. That will give an opportunity to other parties to raise question whether the same approaches have been applied to all these defendants. I have three options to solve it. Option one, not wait, just amend this article, but then for sure we'll have this problem what we would do with older crimes, I mean, relatively older. Second option, leave 438 as it is, but add another article, more specific article, into the criminal code, which would work well. In the meantime, 438 would stay as some general statement. And options three, do nothing until the conflict is over, looking for potential solutions that we're trying to find. And later on, upon completion of the conflict, we will implement necessary amendments to the criminal law. That's where I would like to hear your opinion. Thank you.
I mean, I've also heard some of these concerns that you're raising about, like, if we change it now, then we're going to have this problem of retroactivity and you know, how will we apply the new article to actions that took place in 2022 and 2023? Look, it's I think there must be a way of doing it such that when you introduce the actual elements of the specific violations under 438, that it is this is entirely consistent with 438. It's not changing it. It's explaining or explaining what is the content of 438. So I think I would leave it to the constitutional lawyers of Ukraine who would know the legal techniques of how to do that. I mean, I also hear you about the idea of a practical solution, finding a way around it such that, people have had ideas about really making, sort of templates so that it's very clear which elements of which crimes fall under 438. I think the challenge of that is just to make sure, the challenge of making sure that every lawyer, judge, prosecutor in a country as large as Ukraine with as many war crimes as are being committed in Ukraine to achieve that uniformity of application is a little bit difficult using sort of practical measures. In the end, it's still law that matters the most. And so that would seem to be an argument for finding a solution that, not to create the problem of retroactivity, which you're correctly identifying, but to find a solution of a way to embed and to explain the content of 438 by listing specific violations with their elements. So I'm sorry, I'm not a Ukrainian lawyer, an international lawyer, so I think this maybe goes a bit beyond my ability.
Дякую, пані Ноель. Ми маємо завершальне питання, будь ласка.
Thank you. Now we have a concluding question. In the context of your speech, with regard to consideration of cases in absentia, let me offer you another problem. That's about identification of counsels and clients, because there was a decision made by the Bar Association, Bar Council of Ukraine, at request of those councils who actually defend this kind of offenders, because they often are viewed as those who are guilty. And here we have this problem of lack of guarantees of lawyers' activity.
We've talked to different international organizations, for example, about would you be willing to start a program to support defense lawyers who are defending war criminals? And when you ask that question, people look at you like, oh my God, no, it sounds horrible, right? But if war criminals don't get a fair trial, imagine what happens in 10 years or whatever, and these war criminals claim that Ukraine has violated their fair trial rights, and Ukraine, somebody in Strasbourg says Ukraine has to pay them damages. Can you imagine the reaction? So these people need to get good defense lawyers now so that the decisions that are made comply completely with fair trial standards. How we also see that the quality of defense lawyers in these cases is not what we would hope for. And there's a low willingness to participate in these proceedings. So this is another, I think, a very, very big challenge, and not one to which we found a simple solution. But thank you for raising it.
Дякую, пані Ноель, за ваші відповіді. Ми з вами підходимо до завершення першого.
Thank you now for your response, and we are approaching the end of our first session. I think we set a good tone for the next 2 days. We discussed matters of constitutionality, international law. That means that here we gathered experts in different domains of law. Now we'll have lunch break. We'll meet again at 2 o'clock in the mirror room. We'll have lunch where we had a coffee break. So you're
According to our agenda, we start session number 2, and we shall work for 1 hour and 20 minutes. I would like to tell you that we have had about 70 online participants. I do not know the statistics for this time, but I know that there are lots of people participating online. And now we start our session number 2, derogation from obligations under the European Convention on Human Rights in time of emergency. As you know, Ukraine is in the process of derogating from certain obligations under the Convention on Human Rights and Fundamental Freedoms since 2015. At that time, this derogation covered the territories non-controlled by the Ukrainian authorities, and since 2022, the derogation covers the entire territory of Ukraine, and there are certain specific aspects in relation to derogation regarding the armed conflict, and there are rights which cannot be derogated, and they are supposed to be used in the wartime as if they were used in the past time. And now I would like to announce the keynote speech of the Judge of the European Court of Human Rights, Mr. Petr Pacalai, and the topic is derogation from the Convention in time of emergency. Mr. Pacalai, you have the floor.
Thank you very much. Thank you, my dear friends, inviting me to this very important event on the case law of the European Court of Human Rights. I'm honored and, also very happy to be in Ukraine against, at least virtually, after so many missions that I completed as rapporteur of the Venice Commission in the last 3 decades. As mentioned by our earlier this morning, and even now at the introduction, that derogation, unfortunately, is an actual topic for Ukraine, who had to derogate from certain articles of the convention, has been derogating since last year. So therefore, I want shortly present the Article 15 of the Convention on the derogation in time of emergency. This Article 15 is basically the derogation clause within the Convention, and this derogation clause in the early 50s came from the fact that this political and legal philosophical tradition from the Roman times when the dictator until the recent times, until the 20th century, let's say, of Carl Schmitt's philosophy, entitled in times of emergency, in states of emergency, the executive by unlimited power for a certain time. After World War II, nevertheless, this philosophy was challenged, and this state of emergency, unlimited powers, were also put under the control of, let's say, in this case, of an international court. Because what does say this Article 15? That in time of war, first, or secondly, in any other public emergency that threatens the life of the nation, member states may take measures derogating from their obligations under the Convention, but only to an extent strictly required and provided that such measures are not inconsistent with other obligations under international law. Let me approach these elements very shortly. First of all, let me emphasize that the whole complex is built upon the presupposition that the lawfulness of the derogation is controlled by a court, controlled by the Strasbourg court. I quoted the text of the first paragraph of Article 15. The first notion that we have to approach is the notion of war. the notion of war was not interpreted so far by the court because there were no applications for that. So the applicants never asked the court to interpret, to explain what the notion of war is. So therefore, basically, any war, even it's not addressed the war, so all cases that came to the court in the last almost century was under the second term, namely the public emergency threatening the life of the nation. The only exception that should be mentioned is the case Georgia versus Russia, that was a case about the armed conflict and aggression in Georgia in August 2008. And this judgment, delivered only in 2021, differentiated between the active and the non-active phase of the military conflicts, which was a novelty introduced by this very detailed and long judgment. So, from the notion of war, let's move to the other public emergency threatening the life of the nation requirement. I quote a case, A and others versus the United Kingdom. It was a Grand Chamber judgment from 2009 about the United Kingdom's government decision to introduce a state of emergency and ask for derogation after the 9/11 terrorist attacks in the United States. United Kingdom also asked for derogation because of these terrorist events, attacks happened in another continent, other state. But in this judgment, the court summed up all the previous approaches to the concept of the other public emergencies threatening the life of the nation requirement. First, in the very first judgment of the European Court of Human Rights, delivered in 1961, was named Lawless versus Ireland, was in itself an issue where the derogation was at one of the main topics of the judgment. This judgment was related to the activities of the IRA in 1957, and the judgment had to explain already in the very first judgment of the court what does it mean the other public emergencies threatening the life of the nation. The court said that this notion is sufficiently clear and clearly refers to an exceptional situation or crisis or emergency which affects the whole population, the whole nation, and constitutes a threat to the organized life of the community. In a case in 1969, which was not delivered by the court, but at the time existing European Commission of Human Rights, about the colonialist dictatorship in Greece in 1967. This is a so-called Greek case where actually Denmark, Norway, Sweden, and Netherlands applied against Greece. And here the Commission clarified, and the court is following these requirements, that the emergency should be actual or imminent, so not remote and abstract. It should affect the whole nation, so that's for the whole nation, not only part of it. And the danger should be exceptional, and that normal measures and normal restrictions would be inadequate to manage the situation. In a third case, in Ireland versus the United Kingdom, a judgment from 1978 that was connected to to derogations in respect of Northern Ireland, when in the early 70s there were a lot of emergency measures introduced by the United Kingdom, by England. And this judgment reiterated that Article 15 test was satisfied in the case of Northern Ireland, and terrorism had for a number of years represented a particularly far-reaching and acute danger for the territorial integrity of the United Kingdom. The institutions of the 6 counties in Northern Ireland and the lives of the inhabitants of those counties. The court reached similar conclusions in other cases regarding the United Kingdom about terrorist public emergency, and this was also the line that the court followed in respect of Turkey in a case in 1996, where it accepted that a Kurdish separate violence had given rise to a public emergency in Turkey. So here the standard is made of 2 components. One is that the life of the whole nation is threatened, which does not exclude, that obviously does not does not affect all the territory of the country, but Northern Ireland, the counties in Northern Ireland, or the southeast part of Turkey, these turbulences in those parts of the country might represent a danger to the life and threaten to the life of the entire nation. Approaching the derogation issue, the court, as usually, uses its 2 frequently used tools, the margin of appreciation of the states, and this combined with European supervision. For example, in the previously mentioned case, Ireland versus United Kingdom, 1978, the court summed up very clearly and that first of the responsibility for the life of the nation is for every state to determine whether the life is threatened by a public emergency, and so how it's necessary to overcome the emergency. By reason of the direct and continuous contact with the pressing needs of the moment, the national authorities are in the principle in a better position than any international judge to decide both on the presence of such an emergency and on the necessary derogations. So in this matter, the Article 15, as the entire convention, leaves to the national, the domestic authorities, a wide margin of appreciation to decide on the necessary measures. The second element, quoting again from this judgment, nevertheless, the states do not enjoy an unlimited power in this respect. The court, which is responsible for ensuring the observance of the member states' engagements, is empowered to rule on whether the states have gone beyond the extent strictly required by the exigencies of the crisis. So, the domestic margin of appreciation given generously by the court to the domestic authorities goes hand in hand with the European supervision exercised by the Strasbourg Court. The third element that I just mentioned, just want to point out separately, is the requirement of the strictly required by the exigencies of the situation, where the court uses the usual necessity test and the proportionality test to measure the exigencies, the required exigencies of the situation. I have to mention finally that the violation, even in case of derogations, might be adjudicated by the court. For example, in what I quoted at the beginning, the A and others case versus the United Kingdom, the Grand Chamber judgment from 2009, where the issue was the detention of foreign nationals suspected being supporters of Islamic terrorist operations, who were after the 2001 US terrorist attacks, putting detention in the United Kingdom. So that was the issue. And although the court accepted the wide margin of appreciation in evaluating the situation, etc., as regards Article 5 of the Convention, the court concluded that, and this was the same conclusion that the highest, the House of Lords, the highest judicial instance in the United Kingdom drew, that the derogating measures were disproportionate in that they discriminated unjustifiably between nationals, and these foreign nationals, these suspected foreign nationals, non-nationals. So the court concluded that a violation of Article 5, paragraph 1. Finally, let me turn now to the final element in the definition for the derogation, that the derogation should not be inconsistent with other obligations under international law. The court used rarely this element, but for example, in a case was the Brannigan and McBride versus United Kingdom in 1993 against a public emergency because of two suspected terrorist persons, included Article 4 of the International Covenant on Civil and Political Rights. If you go to this text of the International Covenant, this Article 4 basically has the same, almost literally the same definition that is given by Article 15 of the Convention. Both of them go back to a United Nations draft that on the emergency situation. So here the court quoted another document under international law. Then in another case, it was a Grand Chamber judgment in 2014, Hassan versus the United Kingdom. It was a particular case because this was an event that happened outside the territory of the Council of Europe in Iraq, where the British armed forces were involved in these hostilities in Iraq in 2003. And an Iraqi national, the brother of an Iraqi national, was the applicant. And the United Kingdom has not requested derogation for these military actions in Iraq. And here the court faced for the very first time an issue where the state requested the court to disapply its obligation under Article 5 or in some other way to interpret them in the light of powers of detention available under international humanitarian law. So the United Kingdom argued that they didn't ask for derogation because this action and also the question, the detention, can be exclaimed under other international law documents, namely, they were referring to the Third and the Fourth Geneva Conventions. And the court accepted this argument, saying that it would appear that Hassan's capture and detention was consistent with the powers available to the United Kingdom under the Third and Fourth Geneva Conventions and was not arbitrary. And then they find no violation. In my personal opinion, this argument's a bit problematic because it abstracted the issue from Article 15 and accepted the detention and adjudicated the detention only according to other international law documents. In the already mentioned Georgia versus Russia judgment from 2021, the court referred again to Hassan, saying that the court has made it clear on many occasions that the convention must be interpreted in harmony with other rules of international law. This applies no less to international humanitarian law. My personal position is closer to one of the judges' dissent or concurring with this conclusion, saying that Article 15 would require an assessment of the respondent state's compliance with other obligations under international law, but the preparatory work of the convention provide no guidance how to interpret these terms, these other obligations under international law. So anyway, this is an open question still in the case law of the court. Let me turn to the second paragraph of Article 15, which contains the non-derogable rights. This issue was already touched upon by my dear friend and colleague Judge Gnatowski this morning. So I just repeat, so to say, quite shortly, that the second paragraph mentions and as non-derogable, let me say, as absolute rights in the Convention, Article 2, right to life, respecting deaths resulting from lawful acts of war. Secondly, Article 3, prohibition of torture and other forms of ill treatment. Article 4, prohibition of slavery and servitude. And Article 7, no punishment without law, nullum crimen sine lege. Three of the additional protocols of the Convention also contain clauses which prohibit derogation, like from death penalty in time of peace, like Protocol 7 from the ne bis in idem principle, no double punishment for the same crime, and Protocol 13, we introduced the complete abolition of death penalty. Is the effect of this second paragraph, the non-derogable rights, is that the rights of which they refer continue to apply during any time of war or any public emergency, irrespective of the derogations made otherwise by the state. As regards Articles 2, right to life, Article 7, no punishment without law, the Convention, these respective articles contain already limitations and possible limitations and exceptions from the absolute character of this law. Like, for example, any deprivation of life will not be in contravention of the Convention. It results from the use of force which is no more than absolutely necessary, or the defense of a person from unlawful violence, effect a lawful arrest, prevent an escape, etc. And as regards Article 8, the prohibition of no punishment without law is subject to similarly some restrictions, some possible restrictions, and so there are already consisting, but otherwise these rights are presented as absolute non-derogable rights. The third paragraph of Article 15 deals with the procedural requirements of the derogation, which is a procedure inform the Secretary General of the Council of Europe about the derogations. I think the main purpose of this procedural requirement is to make public the derogation for the international community. The requirement to notify the Secretary General of the taken measures and the reasons for them is usually presented in a letter attaching copies of the legal text under which the emergency measures will be taken. It's, so to say, an unfortunate recent development that member states living with the derogation send very general information to the Secretary General of the Council of Europe. This can be said about the derogation of France in 2015 after the Paris terrorist attacks, and in Turkey that adopted within the framework of state of emergency that was declared after an attempted military coup d'etat. Here there were no detailed reasoning. After 2 years of the Turkish derogation, 2 cases came to the court, adjudicated in chambers on the Şahin Alpay, but I'm quoting from his Mehmet Hassan Altan, the judgment from 2018. These applicants were 2 journalists arrested after the attempted coup in 2016. Here the court noted that the notice of derogation by Turkey does not explicitly mention which articles of the convention are to form the subject of a derogation. Instead, it simply announces that measures taken may involve derogation from the obligations under the convention. So, probably also because of this noted but not condemned general approach of the notice of derogation, the court found violation of Article 5 of the Convention, because this was what already the Constitutional Court, the Turkish Constitutional Court, judged that the pretrial detention was not lawful, and the court also followed this judgment that there was a not reasoned and not lawful, and the procedure detention was not in accordance with the procedure prescribed by law. So that about Article 15. Let me add that during the COVID pandemic, 10 countries of the Council of Europe derogated from the convention. Then many have since, of course, withdrawn their derogations, and why the court just a few days ago announced the judgment that would have been the first judgment, Grand Chamber, on restrictions of convention rights during the pandemic. I'm sorry to say that, well, in this case, the Communauté Genevoise d'Action Syndicale referred to the freedom of assembly restrictions, where the chamber found violation of Article 11, freedom of assembly. The Grand Chamber dismissed the application because of the lack of victim status and with the non-exhaustion of domestic remedies. So basically the Grand Chamber did not address the merit of the issue. Finally, coming back to the derogations made by the government of Ukraine, it was introduced in February 24 of 2022, the state of emergency rule in separate regions of Ukraine and the martial law in the entire territory of the country, and the government derogation from Article 5, 6, and 13 of the Convention, with a detailed explanation of the affected laws and the reasoning. And this derogation, declaration to go ahead with this derogation was the last time registered the 21st of November by the Secretariat General. So thank you for your attention that I wanted to present shortly regarding the Article 15 of the Convention.
Дуже дякую вам, пане Петре Кацалай.
Thank you very much for this review and overview of the case law of ECHR. During emergency situations. While colleagues are thinking on the questions, I have a question. How can derogation of commitments be done when the state does not perform effective control in the territories where the derogation was declared?
Of course, the issue of the procedural issue, that it's controlled by the Secretariat of the Secretary General of the Council of Europe, and the court's case law covers only issues when somebody challenges the derogation made by the country. So, for example, no application challenging Ukraine, and no. So this basically the court's case law does not answer to that issue. Otherwise, I suppose more than that basically the Secretary General registers the derogations and does not adjudicate the derogations. So I think that if a similar request is sent to the Secretary General, then they register the derogation. But basically the states can derogate from when they have obligations. When they have no control over the territory, that in my humble view, they don't have the obligations in the same measure as control over the territory.
Щиро дякую, шановні
Thank you very much, dear colleagues. Any other questions? To Peter, please. Please introduce yourselves. Thank you, Irina Shapovalova, Volnograd District Court of Dnipropetrovsk region. Here's my question. During the martial law, the criminal procedural law of Ukraine was amended, envisaging the transfer of specific powers on the exercising of judicial powers to prosecutors. How do you think this can be interpreted as admissible a level of derogation according to, say, Article 6 of the ECHR, or is it unadmissible because the prosecutor can never, under no circumstances, perform functions that are only pertinent to court? Thank you.
Thank you. It's an interesting question, but honestly speaking, the judges are not allowed to go into speculation. So when this case comes to us, then we form. So I cannot speculate on the possible approach, and even I don't want to share if I have any opinion, personal opinion on this issue. I'm sorry for that, but we are under strict rules.
Колеги, чи маєте ще запитання?
Dear colleagues, any other questions? Okay, let's move on. I would like to thank you once again.
Thank you.
Дуже дякуємо.
Thank you very much. Now we would like to talk about the freedom of movement. The right for freedom of movement is one of the fundamental rights of the human being in a democratic society. It is not absolute. It has certain restrictions to ensure the implementation of rights and interests of other persons, the state and the society, and we will talk about certain restrictions in the interests of security and defense of the state. I'd like to give floor to Mr. Dmytro Tretyakov, Deputy Secretary of the Administrative Tribunal of the Council of Europe, Senior Lawyer of the Secretariat of the European Court for Human Rights. Thank you very much. My topic actually is very interesting. But as was mentioned today, we have a communicated case regarding the details of this case. And we can talk about the details of this case only as much as the questions were formulated by the court to the government. So once again, commenting no, I doubt we can comment on the case that is currently under review. If the judges cannot do this, then the lawyers definitely cannot do this. So, First of all, I would like to give the general overview of Article 2, Protocol 4 regarding the freedom of movement because it envisages certain rights.
It's about movement in the territory of the country to choose the place where you live. And before the war, it was something that was absolutely obvious. But, well, I remember still I had my foreign passport and I had to apply for a visa to go abroad. There were 2 visas that I had, to Poland and to Hungary. So now definitely it's the remnants of the past, it's the part of the Soviet past. But now the issue is raised again in relation to the events happening in Ukraine. But I'll start from the beginning. These rights are not absolute rights. They can be restricted. And they can be restricted in cases stipulated by the law. And they when it is in the interest of the society, in order to ensure the security of the society, in order to protect the rights and freedoms of some other people. So this is once again the 3-element text mentioned in Article 8, 10, 12 of the Convention. First of all, the court is trying to see whether the right to movement was breached, then whether it was stipulated by the law, whether one of the purposes was met, which have been mentioned just recently. So the court is trying to understand whether it was really necessary in this or that specific situation. So there are different cases about it. If we are talking about Ukraine, the article was mentioned, first of all, in cases related to the obligation not to leave the country. And there is a case, Nikiforenko versus Ukraine, where a person, after her ex-husband died, she started living in his flat and actually took a bicycle, which according to her belonged to her daughter. There was a criminal proceedings initiated. It was pending for about 10 years. And for these 10 years, the applicant had this obligation not to leave the country, was obliged not to leave the country. And definitely the court said that this period is definitely prolonged in such a simple case. If we take some recent case law of the court in relation to Ukraine, it was mainly about those persons that cannot go abroad due to the fact that they have financial debts. For example, in one of the cases, the main issue was, and this is a standard practice, the state is supposed to show how the very fact that a person cannot go abroad will help the person to pay this financial debt. And that was the system built at that time. And if this restriction was introduced, it was practically impossible to cancel it. The only ground for cancellation was paying off the debt. And even those people who initiated this restriction, the courts that actually took this decision about granting this point couldn't actually withdraw this restriction. And logically, in that case, there was the violation found, as well as in many others. We also have a case, Jakseverhan versus Ukraine, where the applicant was required to be extradited by another country, and the applicant was not kept in custody, but actually, again, he was obliged not to leave the country. But at that moment, according to the legislation, there were no measures that can be applied to people who expect to be extradited, and Here, the procedural legislation was applied, and again, there was some significant violation here because restriction of movement of the applicant was not stipulated in the legislation. Recently, there have been 2 more cases, and both cases are about the right to go abroad. No violation has been found. In the first case, the law enforcement authorities of Ukraine, at their own initiative, decided not to give the foreign passport to the applicant, stipulating that there is criminal proceedings opened against the applicant in Moldova, and one can expect that probably the law enforcement authorities of Moldova will request them to take these criminal proceedings because the applicant was the citizen of Ukraine and he cannot be extradited. So the court said that they found that there was no violation here because actually the man got another foreign passport and had a chance to move freely. And there was a case Petrakov versus Ukraine, and actually it was about the enforcement of the court judgment because the ban to go abroad was cancelled by the Court of Appeals, but when the judgment was made until the moment of enforcement, actually it took about 40 days, and several days after the court judgment, the applicant wanted to go abroad, but in the Border Guard Service of Ukraine database, there was no information about cancellation of this ban, and she was not allowed to go abroad, and therefore she filed a case against Ukraine. The case went to the court. As far as the current situation is concerned, I'm talking about the situation after the annexation of Crimea. There was a special decision made that it was established that the territory of Ukraine hasn't changed. The Crimea belongs to Ukraine, but it is under the effective control of the Russian Federation. And there was a case that a person actually was trying to go through one of the border crossing points that was closed, and the car was taken from a person, and there was actually a standard issue related to some customs things. The point was how the confiscation of the car and a fine amounting to the full cost of the car is too serious a punishment for this violation. The case is Onyshchak versus Ukraine. And again, due to the current situation in Ukraine, there are lots of IDPs, and also there are some issues related to their rights. I can mention a case, Sergeyenko and others, versus Ukraine. It's about local elections, so the legislation has changed. There are not many cases like this. As far as non-recognized territories, I'm talking about the temporarily occupied territories. So far, there have not been any cases about this, but there were some cases about Transnistria. Well, this is the territory of Moldova, which is now under effective control of the Russian Federation. And in one of the cases, Dobrovitska and others versus Moldova and Russia, Ms. Dobrovitska again was obliged not to leave the territory of the country, that she was obliged not to leave the country by the police of Transnistria. The court considers that the authorities in this non-recognized republic are not the authorities established in accordance with the law, so any restriction of human rights by such authorities is against the law, and therefore the court found violation of Article 2 of the 4th Protocol because these authorities restricted the right to movement, and this is in violation with the convention. The second case is slightly different, is Bula versus Moldova and Russia. And the applicant lived in the territory of Transnistria. His mother was a disabled lady, and therefore he had the right not to go to the army. But when he was conscripted, he decided to join, to enter the military college. Then he decided that he doesn't want to study there, and sometime later he was allowed to leave Transnistria, but when he was a cadet, his passport was taken from him, and he couldn't leave the territory of Transnistria, and he even couldn't move freely in Moldova, and the court found violation of Article 2 of Protocol 4. Regarding security issues, the European Court considered this issue mainly in relation to the military staff and other citizens of the Russian Federation that had access to secret information, and therefore they were restricted regarding their right of free movement. And the court found violation here because these restrictions were not individual but general ones. And the second point, the court said that under current circumstances of technology development, in order to transfer some secret information, one should not go abroad. Therefore, this particular restriction regarding the right to go abroad is not convincing and is not justified. If we talk about cases which have been considered by the court recently, I have already said that apart from this Crimean case and apart from the case Ukraine versus Russia, there is some decision in the case Ukraine and the Netherlands versus Russia, and this complaint was found admissible about movement groups of children through the borders which were not voluntarily, and the court found that this practice means that this complaint is admissible and will be considered on its merits. And today we have already had a case, Kornichenko versus Ukraine, and this is the first case of this kind. The case was communicated on the 30th of October, and we can hardly expect something about this case earlier than the end of the next year. But the case is really interesting because the point is raised: what are the grounds to restrict the right of people who would like to go abroad? And it goes about people who are deprived of this right just because they are of conscription age. In this case, the applicant wanted to leave Ukraine with a minor child on the basis that he is the only person who is taking care of the child. And for 3 times, this man was forbidden to leave Ukraine. And actually what was required from him to provide supporting documents. And again, the documents he provided were not addressed, and again, nobody explained to him why these documents were not enough. And here the court asked several questions to the government. The applicant complained about violation of his right to go abroad during the war. This is the violation of his right to free movement, Article 2 of Protocol number 4. And also the applicant complained that he is discriminated because this ban, this prohibition covers only male people. male applicants. And I know that probably tomorrow there is a special session on it about potential discrimination during the wartime. And the questions of the European Court to the government were actually related to the points that have already mentioned in the lecture of the distinguished judge Berta Patzolai about the derogation made by Ukraine after the beginning of the war and how these derogations are related to Article 2 of the protocol and Article 14 of the convention, and whether this restriction was necessary. I'm talking about the restriction of the right to go abroad, whether it was justified in this situation. And if we take the very right to the free movement, the court asked the following question: whether the prohibition for the male beings to go abroad has due legal ground, whether this prohibition was done in accordance with the law, and whether the law meets the requirement to the quality of the legislation, whether there were requirements mentioned, what particular documents were supposed to be provided by the applicant in order to give him permission to go abroad, and whether the restriction of his rights was the necessary means in the democratic society. And the final question that was communicated to the government of Ukraine whether the applicant has become the victim of discrimination on the basis of gender. Actually, that's everything I wanted to mention about this topic, because you understand that once such an important issue is raised, we cannot predict how the situation will develop and what kind of the decision will be taken by the court. We cannot predict it, and there is no need to do it. We have to wait for the court judgment. This is the information we have for today, and I hope you may have some questions and I'll be ready to answer them. Thank you very much, Mr. Tretiakov. Thank you very much for your report. And now we have Q&A session. Good afternoon. Good afternoon. Thank you very much for your presentation, and thank you for stressing the points about the right to movement, and thank you for providing some details about some Ukrainian cases. I would like to hear the information about the qualification of the violation of this right according to the convention. Probably on the basis of your experience, on the basis of the information that can be made public. If restriction of one right under convention creates some consequences in relation to the other right under the convention, should we qualify it on the basis of two articles of the convention, for example, in relation to the primary right and then to the secondary right, or we qualify it only on the basis of one provision of the convention? For example, restriction of the right to go abroad may influence the right to education. The first protocol to the convention guarantees the right to education, and definitely there are the provisions that guarantee the movement of the freedom of movement. So when we restrict the freedom of movement, and as a result of this restriction, a person cannot go abroad and study there, do we consider it as the violation of two rights, or just the right to education that as a result of the restriction of the freedom of movement won't be exercised? In the case Dobrevitska versus Moldova and the Russian Federation, one of the arguments of the applicant was that because of this restriction to go abroad, he she couldn't go and study abroad. And actually, this is a very interesting issue because there is no unified practice here, and there are many cases on the basis of Article 9, 10, and 11 of the Convention, when the court is just asking whether the key point was in the expression of one's opinions or in the form of demonstration. For example, sometimes the court finds violation of Article 10 or 11, and sometimes two articles are violated. And in the case of Dubrovitska versus Moldova and the Russian Federation, the court found that primarily this is the violation of Article 2, Protocol number 4 to the Convention, and the derivative violated right is the right to education. I hope I managed to answer your question. And do I understand you correctly that there are no clear theoretical criteria for qualification of such situations? So when we have this combination of several situations in one case, it is quite difficult how we can qualify this or that violation. Well, we have cases where certain rights have more significance. For example, the duration of the criminal case, according to Article 2, it may be Article 2 and Article 6 of the Convention, but for me it is, well, Article 2, though there may be two of them.
And in Article 8, we were considering the procedural violations on courts. And the biggest issue there was the violation of procedural rights versus Ukraine. On the other hand, there is the example of the right for parental visitation. The court may consider this on multiple articles, or they may do this differently. And there can be multiple types of complaints, and we can even take into account that this complaint is admissible, but the state may say that there is no need to consider the same question under Article 2 of the Convention. Thank you. Thank you, Dmytro. Irina, please.
Доброго дня. Дякую за...
Hello, everyone. Thank you very much for your presentation. My question is regarding communicated case Konichenko, right? The issues you mentioned in terms of communication to the government, they do not include the position on the exhaustion of domestic legal remedies, or there are no actual features of the use of all domestic remedies. Is it possible that they have to go through the constitutional court or at least launch a complaint? Because the quality of law can be the subject to constitutional complaint. Otherwise, does this mean, at least at the level of discussion, that the constitutional complaint is not an effective remedy? I cannot respond, unfortunately, because I do not know what is left behind the screens, behind the curtains. And even if I knew, I could not share this. I cannot comment this regarding this case, but as to the question in general, the question remains relevant. And as far as I understand, the question remains unresolved. As to the constitutional complaint and effective legal remedy, I hope that over time we will receive this kind of decision. Thank you. Dmytro, what do you think? What are the time limits of potential consideration of this case? Or is it too hard to envisage? As a rule, the fastest I've ever done is around 1 year. This is the fastest. You know, I didn't wait for anything. Everybody sent everything in a timely manner. You understand that now in the time of war, we have longer duration, for example, for submitting concerns of the governments, and there were other issues. Sometimes we have issues with applicants. We may get a request to expand the time of consideration because the person is in the front line and cannot respond on time. But even before the war, in the best case scenario that I've had personally, is around 1 year. We're talking about a case with one issue. But the sort of, obviously, the cases that are considered by one judge, that goes faster, but usually it's not for the benefit of the applicant. Hanna, please. Hello. I would like to raise one problem. You may mention one practice that, or something we could focus on, the problem of persons with de facto dual citizenship. It's different for different regions, but if we take my region, according to unofficial data, because obviously there are no official data officially, this is 30 to 40,000 citizens who have dual citizenship, both the citizenship of Ukraine and neighbor states. Usually we're talking about the citizenship of Hungary and Romania. In our court and in the first instance courts, we have various cases related to border crossing by these individuals. And there's a standard situation. I'll just give an example because this is a very typical situation. For example, outside the territory of Ukraine, the Ukrainian citizen Stepan came, left Ukraine, and Hungarian citizen Istvan came back into Ukraine. He's recognized as a Hungarian citizen. He's trying to leave the country as a Hungarian citizen, but he's not allowed to go out because he is identified as the Ukrainian citizen. He says, I'm not a Ukrainian citizen. The Ukrainian citizen has left and never came back. The Hungarian citizen has left and wants to go back to Hungary. And this is a typical situation. There's another situation which we also faced where, for example, well, thing is, it's not just our country. This is the problem for the border guards, but they're doing something and then we have to deal with it. Another situation where a Ukrainian citizen left the country and a citizen of, well, Hungary or Romania is trying to come back. And we have cases where they are not allowed to enter Ukraine. They're saying, well, we don't see you as wanted here. So we have issues with such persons. Yes, we do not recognize that, but what do we do de facto with this? And the Supreme Court does not get that because these are admin protocols, and there is a problem. Can you give us some kind of orientation for these citizens and what to do with them? What can we do at our level, additionally? Well, this is a very interesting question, and I don't know if we've had such cases, so I would be very careful with these and with the communication. This is an interesting question for me. Clearly, if the person is not automatically deprived of one citizenship and gains the citizenship of another country, we need to look into, how each country treats dual citizenship. There are other conventions to that effect, not necessarily the ECHR, that are always discussing this matter as well, regarding the persons with dual citizenship, etc., etc. But it's an interesting question, I agree, and a very ambiguous one. Thank you, Dmytro. Serhiy, please. Hello.
Таке питання з приводу знову таки
Hello, I have a question on the law, regarding the law. Article 3, Protocol 4 says that restrictions can be applied because of national security. Similarly, in the current situation of Ukraine, the state has reasons to do this. To that effect, our Article 64 of the Constitution, which defines the duty to protect the state, can it only be read as, well, from the standpoint of legitimacy of restrictions or legitimization of what will be defined as a separate law, or is it a norm of the Constitution that can be interpreted more broadly than just the matter of legitimate restrictions? So legitimization of what will be done under the specific law rather than Article 64 of the Constitution. As you know, the matter of direct effect of the norms of the Constitution is always being discussed pretty actively. But again, this is a Kornichenko case that is being actively discussed. So I would like to abstain from comments because there is a case under review which will be considering the matter of the possibility of restrictions for the purpose of protection of the motherland. Besides that, there will be an issue on the Article 15, whether or not Article 15 allows to derogate in terms of Constitution. So I would not like to comment on that, even theoretically. I do apologize, but again, I said that I have the most interesting role today because I have to not say anything about the things that you're particularly interested in. Thank you, Dmytro. We will be looking forward to making decisions. Thank you for outlining the issues. So, colleagues, shall we take a coffee break? We finished our session slightly early. I suggest we come back to this room at 16:30, 10 minutes later, to make sure you have more time. Thank you.
можна вивести на екран наших онлайн-учасників? Спікерів.
I kindly ask to have our online speakers on the screen. We proceed with our forum, and this is our final session that is about execution of the judgments of the European Court of Human Rights. And this is the final stage of the rule of law, which is actually created by the judgments of the European Court of Human Rights. And actually it is similarly important as the very judgment, because the execution of the judgments are very important, and this is the very stage where we see the practical implementation of the judgments of the European Court of Human Rights. Ukraine has lots of judgments about the violations, and therefore we have quite extensive experience of execution of the judgments. Sometimes we are successful, sometimes we are less successful, but we are evolving. And definitely everything is done under the supervision of the Cabinet of Ministers of the Council of Europe. So the topic addressed today will be execution of the judgments of the European Court of Human Rights by Ukraine. And we shall talk about the decision Bromwich versus and others versus Ukraine. And I would like to give the floor to Nadia Zadoroshna, who is the legal expert at the Department for the Execution of Judgments of the European Court of Human Rights of the Directorate General of Human Rights and Rule of Law of the Council of Europe. Good afternoon, dear participants of this annual forum. Good afternoon, dear organizers of this event, the representatives of the Council of Europe project. I'm glad to participate in this annual forum, and once again, thank you for this opportunity. The topic of my presentation today is the execution of the judgment Bromwich and others versus Ukraine, achievements and challenges. Unfortunately, this is the long-standing judgment that is being executed by Ukraine for many years. Therefore, we have been discussing this topic for many times at this platform and at many other forums. And certainly, the Cabinet of Ministers has been reviewing the progress made by Ukraine in the execution of this judgment. I would like to remind you that since our previous discussion in 2020, the Cabinet of Ministers reviewed this case 3 times. In 2021, 2022, and 2023, and definitely this topic was on the agenda of the Cabinet of Ministers in March 2022, but due to the full-scale aggression at the request of the Ukrainian government, the review of this case, the consideration of this case by the Cabinet of Ministers was postponed. I would like to briefly remind you the challenging issue in the case Bromwich and others versus Ukraine, and I would like to tell you about the position of the Cabinet of Ministers, about the progress made in this group of cases and the challenges. The point is about non-execution or lengthy execution of certain judgments against the state enterprises. This is Article 6 of the Convention, and lack of legal remedies, Article 13. This is a structural issue, unprecedented issue, and it has systemic negative consequences for the legal system of Ukraine, because actually it prevents from exercising the rights guaranteed by the Convention. The fact that the national court judgments are not executed results in the case that the rights cannot be exercised within the national legal process. And we see that there are some judgments of the European Court of Human Rights, and we have this point related to these cases. For example, the cases about stopping the bury procedures close to the house of the applicant, or, for example, the cases related to the return of children within the Hague Convention. And the courts referred to the systemic problem of non-execution of the national judgment. So we see how complicated the issue is. And the point that the national judgments are not executed puts at risk the rule of law and the access to justice, and undermines the trust of citizens and of companies to the legal system and to the judiciary in general. And it is not only mentioned by the Cabinet of Ministers, it is also was mentioned in the conclusion of the European Commission about the membership of Ukraine in the European Union application. It is written that lack of capacities of the state authorities to enforce the court judgments is the key challenges to the rule of law. As I have been working in the department for a long period of time, we see the evolution of approaches on the part of all the national authorities in relation to those issues which are related to such cases as Burmich versus Ukraine. What is the evolution? Currently, we have general awareness about the essence of the problem on the part of all stakeholders and responsible entities, which was not the case several years ago. And also from the communication with the government and other stakeholders, we see that there is the willingness to address this problem. And now I would like, by analyzing all the achievements and challenges, I would like to study whether we are talking about the external willingness to do it and whether we really have made some practical progress. But I would like to remind you that it should not only be just the willingness. It is actually the obligation of Ukraine as the candidate to the membership in the Council of Europe, and this is its obligation under the Convention. And the necessity to enforce this judgment is not just because it is stipulated so by the Convention, but it is also related to certain economic, financial, and reputational challenges Ukraine faces due to non-execution of such judgments. So we see that at this stage, and it is stressed by the Cabinet of Ministers, that at the national level, there is improvement in the understanding that by addressing the root causes of this problem, Ukraine will manage to resolve the issue not only to its obligations under the Convention, but also will untangle the whole range of economic, financial, and other problems, and will address and will be able to develop a new management model. What I mean? In 2021, Ukraine adopted the national strategy and action plan to resolve this Burmich case and identified the root causes of the problem and identified the responsible authorities. I would like to say that the primary problem identified by Ukraine was insufficiency of state funding, but we see that the problem is more serious and actually it covers the entire system of the state authorities. I'm talking about executive, legislative, and judiciary authorities. Now this action plan is updated by the government, considering the peculiarities of the full-scale war and the challenges brought by it. In addition to the national strategy and the government action plan, the Secretariat has prepared the rigorous analysis of these root causes. 7 problems were identified, and the list of recommendations was provided. And the Cabinet of Ministers encouraged the state authorities to include these recommendations into the updated action plan. Going a bit ahead, I would say that the Secretariat is preparing the updated document in order to reflect the changes that happened from 2021 till the end of 2023. And these two documents, the government document and the Secretariat analysis, give us the so-called helicopter view for us to be able to see the comprehensive and integral, holistic essence of this problem. The last time when the Cabinet of Ministers considered the execution of judgment in the group of cases Burmuch and others versus Ukraine was in September 2023. And the Cabinet of Ministers stated that they understand the challenges faced by Ukrainian authorities due to the aggression and how the entire situation may influence the execution of judgments in the group of cases Burmuch and others versus Ukraine. Definitely now there are other priorities, for example, security issues and social issues, as stated by the government. Still, Ukraine has its obligations at the highest political level, and these obligations presuppose full compliance with its obligations under Article 6 of the Convention. And during the recent analysis, the Cabinet of Ministers stated that though there have now been significant major achievements and progress, and previously it was planned that the preliminary resolution should have been adopted, and it was supposed to be resolution number 9, but the Cabinet of Ministers decided to come back to this review in September 2024. And in case there won't be any progress, the preliminary resolution will be taken at the next session. Regarding the conclusions of the Cabinet of Ministers about the performance of specific state institutions that were supposed to address the problem of Burmuch, the Cabinet of Ministers said the following. First of all, it welcomed the willingness of the state to update and adjust to the current circumstances the action plan, encouraged the authorities to speed up this process, and stated that the previous action plan didn't presuppose specific funding, and this aspect should be addressed in the update of the document. And unfortunately, as I have already said, due to lack of significant progress, the Cabinet of Ministers stated that the level of execution of the national judgments from the information provided by the state is almost close to zero, because these are only the state enforcers that can do it, and the Cabinet of Ministers stressed the importance to avoid new social obligations without proper financial foundation for such obligations. And the Cabinet of Ministers urged the government and the Parliament of Ukraine to develop the corresponding legislation and provide for a state budgeting of the proposals in question. The Cabinet of Ministers also stressed the importance to cancel certain moratoria that block the execution of the judgments. And within this context, the Cabinet of Ministers reiterated that there is the criminal proceedings in the Constitutional Court about the legality of such moratoria, and the fact that the Constitutional Court will be reviewing the legality of these provisions and will somehow influence and bring them in order, will bring them in line with the Constitution, and hoped that this verification will be finished quite soon. And the Cabinet of Ministers expressed its regret that still there is no complex system of data collection, in relation to the financial judgments and in nature related judgments, and oblige the state to develop this system. Now, I would like to say that from communication with the government and from some other communications, I would like to say whether we see some progress or the lack of this progress. As far as the data collection point is concerned, about the volume of the debt, about the number of the non-enforced judgments, about the dynamics behind this process, the government provide some inconsistent statistical data. For example, if we take the amount of the debt, we see that the debt of the municipalities is not part of the statistics, and from the recent information provided by the government, their calculation says that now the debt amount to approximately 1 billion euros, according to the court documents. In the preparation to the parliamentary hearings and according to the reporting of NGOs that are based on the public information, we see, well, actually, it is stated that the debt in relation to court judgments may amount to 1.5 trillion hryvnias, and it's about the debt of the state and the state enterprises. Regarding the statement of the Cabinet of Ministers about the peculiarities of the executive proceedings, the participants of the forum know from their practical experience that now we are talking about digitalization of the execution of executive proceedings, and after 3 models of the system were introduced a couple of years ago, we know that since October it is mandatory to use the electronic cabinet or electronic account, and it is really important to ensure automatic execution of the court judgments, which was mentioned by the Cabinet of Ministers, and this is one of the ways of doing it. And I would like to make a tiny remark. When we mean automated, we mean that the data doesn't have to take certain measures, additional measures, to ensure execution of the judgment. When we are talking about automatic execution of the judgment, we may talk about automatic compensation for non-execution of the judgment and about removal of the illegal barriers for the judgment execution. So apart from the actions that have already been taken, we see that there should be some improvements in order to automatically send the judgments to the Treasury Office, and we should really avoid some additional formal barriers. We should mention a specific category of cases, and these are decisions where we have the natural compensation in natural form. And the Cabinet of Ministers also made a statement about it, because at the current stage, it is not possible to count the number of these judgments with all the indicators. And as a result, we cannot clearly understand the obligations behind these judgments, the type of creditors for the state to address the challenges. And there are a number of draft laws related to this topic, and probably the next speaker actually will mention the point. The draft laws in question presuppose the possibility for the creditor to change the way of payment from non-financial into the monetary one. There are 4 of them now, and as far as I remember, they are at the initial stage of the legislative process.
Хотіла би зазначити ще у відповідь на критику
I would like
комітету.
to note, while responding to the criticism of the Cabinet of Ministers, based on the communication with the government that we can see, the matter of review of the state responsibility, bankruptcy of state enterprises, management of state enterprises, and moratorium. If we start with moratorium, then without going deep into the topic, we can just say that the matter of moratorium, moratorium as a method of dispute resolution, does not follow the spirit of the convention, and from the beginning of the full-scale war, we can see that Ukraine has introduced a number of limitations that can de facto be seen as moratoria. Besides that, there is a number of draft laws that can also expand the scope of the moratorium. And obviously, at this stage, and at any time, moratorium is always a politically sensitive matter, but at the same time, based on the case law of the ECHR, the immunity of state enterprises should not, it should not have any exclusive status. It needs to be reviewed and abolished because it contradicts to res juridica principle of the rule of law. Because de facto in Ukraine, they are protecting controlled state enterprises that are doing private commercial activity. They protect them from enforced actions in certain sectors of economy. As to the matter of review of the state responsibility, at this stage, the state's approach that is responsible for the decisions on even in the enterprises where it can be a minority shareholder, again, this approach can be changed. And in fact, it needs to be changed. As to the matter of state management of controlled enterprises, I would note that according to the Secretariat, at this point, Ukraine has started the reform of corporate governance of state enterprises and adopted a strategy of state enterprise reform. In that sense, the State Property Fund is playing a very important role. And according to the National Economic Strategy until 2030, at this point, up to 40% of state enterprises only exist on paper. Therefore, the reorganization or corporate management of state enterprises, like I said, has started with this positive change. Because if we extrapolate this on the decision making against these decisions on state enterprises, this work can help identify the non-existent enterprises which cannot perform their functions. We can take an audit of the existing executive provisions and proceedings. I would also like to outline a huge number of issues, huge sort of plethora of problems are related to the biggest part, even of Drubich, on the social payments. As the Cabinet of Ministers has shown, Council of Ministers has indicated that we need to continue reforming the social legislation and review this question. We can see that at this point, Ukraine is drafting the social code, or rather new approaches to the social code and to management of social payments. Our colleagues from other projects are saying that even the two books of the social code have already been processed, and as soon as Ukraine has any changes in this process and informs the Council of Ministers accordingly, this will be a big progress, particularly in Ivanov-Burmich case. My time is running out. I would like to note that Ivanov-Burmich problem is a systemic problem with comprehensive nature, and it requires common political will, devotion of the authorities, and Ivanov-Burmich case resolution is first of all in the interests of Ukraine, because this is where we started. This will help eliminate dysfunctions in the national legal system, will improve the trust in judicial authorities. And besides all that, this problem or its solution is becoming particularly relevant in terms of Ukraine's willingness to integrate in the European Union. Because the European integration strategy requires compliance with Copenhagen criteria. What do I mean by this? These criteria include, among other things, the rule of law and respect for human rights. And this is what the European Commission stated in terms of Ukraine's EU membership application. By way of summary, I would say that, of course, everyone is following the process of establishment of the registry of losses and damages. And Ukraine's inappropriate actions in Ivanov-Burmich case may potentially negatively affect the legal relations that the applicants and the state will have. And this may give them the right to further address the ECHR. To make sure it doesn't happen, I would emphasize once again that at this point, Ukraine should adopt comprehensive measures to finally make sure that Ivanov-Burmich group of cases is finally resolved. Thank you. I'll be happy to answer your questions. Thank you. Do we have any questions? Dmytro, please. Thank you for your presentation. Dmytro Gudima, I wanted to clarify this. Of course, the presentation emphasizes the debts of the state and problems with resolving cases where the state is the debtor. As far as you know, what is the percentage of problems with court decisions that are not being implemented, or where this happens between private law subjects, where there is a court decision adopted, but unfortunately no results are achieved to implement this decision because of imperfect mechanisms or because of the inappropriate contents of the decisions. If you know the percentage of these cases, please note. Well, I do not have statistical information, but as to disputes between private individuals, there are two aspects there. First, the Committee of Ministers is limited in their analysis by the decision of the ECHR. So the pure dispute between individuals is not subject to Ivanov-Burmich case. But if the non-implementation is happening because of inappropriate system of court decisions implementation with, say, private bailiffs, then this is part of the Ivanov-Burmich case. Statistically, I cannot give you this information, This information should be available at the government. Yeah, if I may, I would like to ask the moderator, since there's a question that this is general discussion, I would explain this point, if possible, with the permission of the moderator. As far as I understand the Ivanov-Burmich case, they're generally related to the implementation of any existing court decisions, regardless of the debtor. Whether it's a state or a private individual, question is how to make sure that the existing decision is actually implemented. Unfortunately, there have been multiple cases where the court decision, is made in favor of the person who is owed the debt, and there is such a decision that, it cannot be satisfied, and no court trial has been satisfied. Over the past 5 years, the Supreme Court was focusing the courts to protect the rights and interests only through effective legal remedies, to make sure that those decisions that are being made are being implemented, and the need to satisfy the conditions that could further be, satisfied. It's one of the actions in the course of Ukraine's implementation of commitments under the convention and based on the ECHR decisions. I've asked the question in view of the fact that we have seen the problem of these cases made when the decisions are being made, when there are multiple decisions to satisfy the demands, the person goes to court second time, third time, the same decisions are being made, but they do not protect the rights, but they instead become the prerequisite to take a new turn at the courts. This is, I'm saying this by way of explaining what else the state is doing to make sure that the court decisions are properly implemented. For instance, they're focusing the court practices, the case law, to make sure that decisions are being made in such a way that they cannot be implemented. Dmytro, I completely agree with you, but we all know that the courts cannot go beyond the requirements of the application, if that's how the court stated. Well, the question is, should we satisfy everything? Court decision has to be implementable when it becomes valid. Obviously, there are cases where the agreements are not valid, but when it's about debts, it would be appropriate to make sure that the debt is collected, and then the requirement to say that the non-payment of debt is illegitimate, and then there's no way to implement this. If it says that the dispute does not allow to resolve the dispute because no debt will be collected, this demand cannot be satisfied. It can be partly satisfied while understanding the purpose of this request, to make sure that it is collected. This is what we could write in the decision. And in the ECHR decisions, there are multiple decisions in 2023 that explain how this can be partly satisfied in terms of conditions that cannot be a legal remedy in themselves. On the other hand, if the purpose of the verdict is not clear, or it has to be done to review other conditions, and then the applicant has gone to identify priorities, maybe even if they are right, but there's a sort of valid court decision, it may not be a legal remedy, because this way you're trying to review a different court decision, and you're trying to substitute one decision with another. And this needs to be mentioned as well. And I think the state should also note that, not only in terms of the reform of legislation on social protection within the cause of Ivanov-Burmich case, but it has to follow the track that all court decisions, regardless of the trial participants, be it states, stakeholders or private stakeholders, all of those decisions have to be implementable if the court envisages the need to implement this court decision. Thank you. Nadia, if possible, by way of comment, I'd like to give floor to Mr. Roman Babi, and then next. Again, by way of discussion. I don't think it's much of a question, but more of a reflection on what Dmytro was saying. The Ivanov-Burmich case, yes, relates to the implementability of court decisions. If we follow the context of the ECHR towards implementation of decisions versus the state and state enterprises, then obviously when we reform the sphere, we will be improving the procedure of decision-making with the private stakeholders. Dmytro was saying something else. He was talking about effective legal remedies. The committee has raised it, and I hope that, well, there are truly different opinions. Similarly to what Dmytro is saying, there are other opinions. There are draft laws to that effect, and we hope we would be able to discuss on this question. I'm grateful to have heard your position, and now I know who I need to involve in the discussion when the effective legal remedies question and appropriate legal remedies are full subject to discussion. This is not so much about the bailiffs, but about the court, really, or to the parties that are formulating their trials in that way. Well, I've explained the idea and the connection with the implementation of court decisions. We must not allow the inflation of existing court decisions, and the concept of these legal remedies was focused on the fact to make sure that the legal system, the court system of Ukraine, does not have the decisions where the resolute part is formulated in such a way where it disallows the implementation. Well, involve Council of Europe in this discussion because we have a lot to say on that. Thank you. We will move on to the next speaker. Thank you. Dmytro mentioned, and mentioned very appropriately, this matter. Well, first of all, there is a group of cases under consideration. I cannot remember the actual name of the group of cases, but it's about the decisions. When the national courts' decisions were written in such a way where this was against private individuals and the dispute against private individuals, where the parties could not achieve their implementation in any way. When the discussion happens at the national level, please note that there is a group of cases under consideration. We're talking about the same things exactly. Okay, but please be brief if possible. Another question from colleagues watching us online. It's not about categories of Burmich cases, but it's also an important case regarding the satisfaction of civil lawsuits in a criminal case, and respectively the absence of legal remedies to the existing damages within criminal proceedings. And here's the question. Is there any responsibility of the state or some compensative mechanisms in such?
Мається на увазі, якщо чесно, я не до кінця зрозуміла запитання. Мається на увазі
I have not quite grasped your question. So we have a civilian claim in the criminal proceedings when the convicted person doesn't have any financial means, and probably the victim, right? So the victim and the civilian plaintiff in a criminal case. I think this question goes a bit beyond our discussion in relation to Ivanov Burmich case, because the very nature of the question is, well, totally different. Unfortunately, I cannot tell you whether the European Court on Human Rights has some specific cases against Ukraine in relation to this point. Nadia, thank you very much for your presentation and for this discussion. And we should go further from something specific to something general. I will put it like this. And now I would like to give the floor to Mr. Pavlo Pushkar. He will be talking about execution of the judgments of the European Court of Human Rights by Ukraine within the period of war. And we shall talk about a broader context. Do we have Mr. Pushkar online? Well, I'm here, I'm online. I hope you hear me. Mr. Pushkar, you have the floor. Coordinator of the DGI Task Force on the Register of Damage, Head of Division of the Department for the Execution of Judgments of the ECHR, DGI, Council of Europe. Thank you very much for the opportunity to present my topic at this forum. It was really interesting to hear the previous discussion about Ivanov Burmich case, and it's really great that we have this institutional discussion between the judiciary and the parliament, and definitely this discussion is of great interest and we can listen to it for a long period of time. But as Ms. Nadia said, it would be nice for us to achieve some specific results regarding these cases and regarding the reform in relation to these cases, as was mentioned by Roman Babai. On behalf of the Department for the Execution of Judgments of the ECHR, I would like to welcome the participants of this forum. I would like to express our gratitude to the organizers, the Lviv University, OSCE, the School of Judges of Ukraine, the Supreme Court of Ukraine for organizing this meeting and for inviting all the participants to this discussion. It's a great honor for me to be a participant of the forum. Since the very first day it was established, it's important that this forum takes place even during this complicated and tragic period for Ukraine. Irrespective of very difficult conditions, Ukraine is committed to its obligations in relation to the Human Rights Center Convention and continues its cooperation with the European Court on Human Rights, the Cabinet of Ministers of the Council of Europe, in order to implement the provisions of the Convention both at the national and international level. A couple of facts in relation to the execution of the judgments of the European Court on Human Rights. Since the escalation of the Russian aggression against Ukraine, since February 24, 2022, up till now, the ECHR has made 21 chamber decisions versus Ukraine and 208 judgments on merits about violations of the provisions of the Convention. The Cabinet of Ministers of the Council of Europe supervises the execution of such judgments, and the activity on this supervision is still ongoing. As of this time, we may talk about the number of cases closed, but at the same time, we may say that in 2022, 62 cases were closed, and there were 16 leading cases, and in 2023, 65 proceedings were closed. Out of them, there were 9 leading cases and 7 on amicable regulation. And there are more cases that will be discussed at the final session of the Cabinet of Ministers in December 2023. Considering this and the topic about the execution of the judgments of the European Court of Human Rights during the war, and this is not an easy topic for discussion, definitely we can mention here many points, but considering the essence of the topic and the supervisory processes, I would like to address some fundamental issues in relation to the execution of judgments of the ESCHR. And I would like to mention three key statements. Why execution of ECHR judgments is of priority importance for Ukraine. The second point, what are the legal and quasi-legal obstacles exist for the implementation of these judgments, and what are the factors they are connected with? And the third point, how we can overcome these obstacles and why is it important considering the events happening now? Answering the first point, what is the execution of the judgments of ECHR and why it is important for Ukraine, one can answer the following. Let's remember that from the viewpoint of our obligations to the Council of Europe, execution of judgments of the ECHR is one of our key obligations under Convention, and this is part of our statutory obligations in relation to the Council of Europe, and non-execution of such judgments is the violation not only of the Convention but also of the Charter of the Council of Europe. And the very practice of implementation of the Convention is not only about the case law of the court, but also the practice of the Cabinet of Ministers of the Council of Europe on implementation of these judgments, which fixes the international customary law. From the viewpoint of international obligations of the state and reputational risk, one may say that the requirement to execute the judgments of the court is the requirement that comes from the finding of the state's violation of its obligation under the international law. And we are talking about such principles as compliance with the principles of the international law to perform one's duties and to perform one's duties on the basis of the international agreement. And we are also talking about the reparations, so restoration of the violated rights, stopping the existing violations, and the practice of the Cabinet of Ministers of the Council of Europe is the reflection of the sources of the international law. The third point, from the Euro integration point, this is about joining the order of the civilized Europe. It's getting away from the Soviet system. It's the modernization of the Ukrainian legal system. This statement is based on the European Union right that the Convention is the part of the unified constitutional space and the Charter of the Fundamental Rights of the EU. And again, we are talking about that it is related to the Ukraine's joining the EU, and certain negotiation issues are related to the question of executing the judges of the European Court of Human Rights, and it is reflected in the recent report of the European Commission about Ukraine's joining the EU. And it is also important if we are talking about expansion of the obligations of the European Union, particularly after Amsterdam's agreement coming into effect in 1999 and expanding the jurisdiction of the Luxembourg Court. In particular, we are talking about mutual relations between the two systems of the right of the EU and the rights under the European conventions. And these questions are becoming more and more topical. The fourth point. This is important for Ukraine regarding social solidarity and harmony. We are talking about person-oriented approach to the law and to the convention in general that is reflected in the convention, and it serves in the interest of the Ukrainian state and the society, just considering the problematics and relationship regulated by Article 1 of the Convention about exercising of one's right and ensuring conditions for accessible legal remedies, Article 15 of the Convention. The fifth point, it is also useful for the legal system. The judgments of the court are important not only from the transformational point, but they also allow to transform the legal system. They allow us to study the best practices of the other member states of the Council of Europe. And here one should stress that execution of these judgments is the objective, technical, managerial process of non-controversial and political nature. The sixth point, from the viewpoint of the legal field of Ukraine and the constitutional law in general, it is the obligation of the constitutional character, the right to execute the judgments of the legal institution, and from the viewpoint of Article 9 of the Constitution, through which provisions of Article 6 of the Convention become really significant. Finally, these advantages may be listed from the viewpoint of other legal advantages and reputational challenges. We are talking about the interest of Ukraine in compliance with its international obligations. This is also the advantage of implementing its international obligations and proving difference of Ukraine and attitude of the Ukrainian experts to the international system and openness of the Ukrainian system. And it's about the compliance by Ukraine to the global values. It's about the rights of Ukrainians to be part of Europe, unlike of the repressive Soviet system of law, which does not recognize the international law and the human rights as the category. And we are talking about just legal categories, but we also should take into account the value-based categories, because the fact that these categories are closed and not addressed poses the threat to dictatorial regime in any country. To put it simply, these categories from the viewpoint of the EU are not part of some legal connections. So what are the obstacles in relation to the execution of these judgments? And this is my second statement that I would like to address. First of all, we should remember the story of the convention. One of the founders of the convention, Winston Churchill, in 1949, considered that the states to which the judgments will be applied won't be able to object about execution of such judgments, because these judgments will be produced by the international institution that will have a great authority and legitimacy on the international level. And as a result, the state won't be able to non-execute these judgments of this institution. Non-execution of the judgments of the court have become a problem for a number of states. For example, for the Russian Federation, before it was expelled from the Council of Europe. Now it has about 2,400 unexecuted judgments, and the total amount of debt is about 2.1 billion euros, including 1.7 billion euros in UCA's case. They refuse to execute the judgments or delaying the execution. I'm talking about both individual means and general means, and prevention of such violations was the fact that Russia does not meet its obligation to the Council of Europe and its obligations and the provision of the Convention. And it shows the problem with the human rights and the legal system of the Russian Federation and enhancement of the authoritarian tendencies in the Russian Federation. We hope that the dialogue about execution of this judgment, the hopes that the dialogue would resolve the problem were actually futile, and we see that the national law prevails over the international law, and the international law does not comply with the Russian law and order, and again, the Russian Federation didn't agree about its exclusion from the Council of Europe. One of the inspirer of the convention said that there is collective national responsibility for implementation of the provisions on the convention, and the states are represented in the Cabinet of Ministers, and the national parliaments and the courts, including the Constitutional Court, should be effective in order to ensure effective implementation of the judgments of the European Court on Human Rights. And this requires understanding of the legal nature of the violation, the root causes of the violation, including the indicators, and we should separate the root causes of the violation from the legal consequences of the violation. We should identify the ways to restore the violated right, what we should do to stop this violation and prevent some further violations. And the judgments of the ECHR are reflected through this complicated legal system. Execution of the judgment is the process that is based on subsidiarity principle. The state chooses the ways how it can implement and execute the judgments, and on the other hand, it should be done in practice with the European Court, acquis communautaire, the practice of the Cabinet of Ministers, etc., by other sources of the international law, soft law, and other guidance and recommendations of the Council of Europe, in particular the Venice Commission, the Committee on Prevention of Torture, Social Charter of the Commission, etc. Subsidiarity is clearly regulated in this case, and implementation of execution of each judgment poses legitimate expectations about the ways it can be executed. However, one of the major complications is the fact that the judgments of the European Court are declarative in its nature. And here comes the natural question, how we should understand the obligations on the basis of the declaration and convention. In the majority of cases, the court does not state how a certain violation can be addressed. And this is actually not the goal of the proceedings. The goal is to see whether the provisions of the conventions were observed. And the Court on Human Rights is usually not indicating the guidance what should be done. The court awards the just satisfaction to the victim, moral or material damage and compensation, and in case there are no proper legal remedies, for example, in case of Alexander Volkov versus Ukraine, or when, for example, a structural problem is identified, as in the case of Ivanov Burmich, or in the case of Sukachov, which is about the penitentiary system, on the basis of some pilot judgment, may recommend certain individual or general means. Apart from this, European Court on Human Rights has its own jurisdiction, and we see the practice of the European Court
But there is this practice regarding Ukraine as well, and it is related to the new court decisions based on the ECHR. We can remember Bochin case, Yarna case, and other cases reviewed in the national courts. What are the legal consequences of the legal recommendations of the Council of Europe and the practice of the Cabinet of Ministers of the Council of Europe, Council of Ministers of the Council of Europe? And this can be split into the fair satisfaction, correction of violation, elimination of residual violations as to the person under the convention, repeated proceedings, additional investigation, apologies, etc., or restitution and integrum. In general, the reinstatement of the state that existed before the violation, for instance, the return to status quo ante. And general nature measures, the commitment to of non-admission of such measures, additional court cases, administrative cases, measures. And the implementation of such measures is allowed by the soft and hard law of the Council of Europe, case law of the states, the security of the Council of Europe, and we may speak that the Council of Europe and the Council of Europe itself, through the decision of the ECHR, is speaking with one voice there. It is unavoidable that the decisions of the court have the consequences that go beyond the measures of specific case, particularly in the cases where these violations can stem from the positions of the law or established national court practice. However, a decision of the ECHR itself cannot annul these decisions independently by the law or by the court practices. The decisions of the law are basically declarative and leave the choice for the state as to the measures that will be applied in the national system towards implementation of its commitments under Article 46. In general, the commitment to make those decisions is the commitment to achieve specific result, full and complete remedy of the ECHR decisions. Implementation of the ECHR decisions. Papamichalopoulos case versus Greece in 1995 also stipulates that. Usually the states are operating in good faith and are trying to implement those decisions. This is based on the oversight on the decision-making. Generally, it is clear and it is pertinent to the Ukrainian situation that the legislators are working appropriately to make respective changes to the legislation that violates human rights, and court decisions in the Ukrainian situation. Unfortunately, someone's mic is on. Wherever it is necessary to prevent violations found in the ECHR decisions. The constitutional courts and the practices of the Ukrainian legal system recognizes the problem in terms of constitutional law and certain laws and respective amendments to the legislation that contradict the requirements of the convention. As to point 3, what are the legal and quasi-legal obstacles that exist in the ECHR decisions? What are they connected with? How can these problems be eliminated? And so on. Here, I would like to say the following. The practice of the Committee of Ministers of the Council of Europe states that there's a big problem related to continuous growth of the number of cases that is under the supervision in terms of implementation for more than 5 years. This is pertinent to Ukraine as well. This is related to legal problems considered by both the court and the Committee of Ministers for a long time. From the standpoint of the preliminary and prior decisions of the court on the same topic, and from the standpoint of the work of the Committee of Ministers. Despite undoubtful progress in the decision-making and the implementation of the ECHR decisions, in the implementation of decisions against Ukraine, despite the war, the general statistics is still showing significant problems in terms of numbers of decisions against Ukraine, decisions related to high-profile cases, and the number of problems and difficulties and complexities of the structural nature. The complexity is quite high, and the number of such proceedings is quite high. Next challenge from that standpoint is the decision of on high-profile cases, complex cases, large-scale problems of the functioning of the legal system of Ukraine, and the problems of their implementation does not always stem from the problems of the war, and in most cases it is unrelated to the war. These problems include elimination of tortures. For instance, in the case of Kaverzin, which will be considered by the chamber in December, the reform of prosecutor's office, judicial system reform, etc., etc. The Committee of Ministers more and more faces the difficulties related to, and we may use the war terminology, with the pièces de résistance that are deeply rooted biases versus the Roma, versus sort of ethnic reasons of commitment of crimes, Maimulakhin and Markiv versus Ukraine on the problem of sort of single-sex marriages, the problems related to national security, in the extreme measure on the limitation of rights offered by Ukraine in the context of convention. And even in the situations that are related to the general practices of the ECHR, in the war conflicts and the frozen conflicts, etc. Obviously, these cases require a lot of effort from these states and the Committee of Ministers and the departments on this Council of Europe and its Secretariat as a whole. I would like to note that there's a report of the year 2000 of the Parliamentary Assembly of the Council of Europe that lists the problems related to implementation of court decisions. It includes political reasons, economic reasons, budget problems, reasons related to public opinion, as well as unclear decisions of the ECHR and lack of definition of the consequences and the problems that they raise. We may say that these significant problems and sometimes complex problems sometimes require innovative and decisive and sometimes long-term persistent actions. In the report from 2023 at the high-level conference on the role of judicial power in the implementation of the ECHR decisions, Schiffer O'Leary, the rapporteur for Ukraine, outlines 4 types of obstacles towards implementation of ECHR decisions: practical or political resistance, financial difficulties, lack of effective mechanism of implementation at the national level, and resistance caused by references to the national constitutional identity. I doubt that all of these segments are observed in the long-term implementation of Ukraine. Some of them do emerge, but Ukraine has never been relying on the willful resistance against ECHR decisions as the key obstacle to implementation of these decisions. But this odd intention was there in the Ivanov Burmich case. The national constitutional identity issue also something we'd like to elaborate in this context. I do not see any legal or other reasons to think that this obstacle may exist. I'll quote 2 things. The influence of the law of the Council of Europe on the formation of Catalogue of Rights and their establishment in the Ukrainian context, and the full-scale implementation and constitution is usually pretty synchronous with the ECHR practice. However, some cases identify, while using the military terminology, the sort of clusters, the pockets of resistance that cannot be resolved quickly. For example, the problems related to ineffective functioning of the legislation system, shortage of resources of the judicial power, Mary and Svetlana Naumenko versus Ukraine, and also partially group of cases of Alexander Volkov et al. The excessive use of pretrial detention, Ignatov versus Ukraine, and various other complex issues of legal nature related to the implementation of the property rights. For example, the moratorium on sale of land plots of for agricultural purposes. The matter that was partly resolved, and the review of the cases of asylum Kebe et al. Case. All methods of interaction need to be used to eliminate these shortcomings, both at the level of the Council of Europe and at the national level. At the level of the Council of Europe, that involves interaction of the cabinet of the Committee of Ministers and departments of the court to help Ukraine provide expert resolution of these measures. Coordination of the needs in coordination, improvements of the European Court's decisions, implementation mechanism, and cooperation of all mechanisms of the Council of Europe that provide expert and analytical work in order to provide assistance to Ukraine within the plan of cooperation between Ukraine and the Council of Europe. Well, yes, I'm wrapping up. I'm coming to my conclusions. That is very good. For instance, it would be nice to further develop national structures that are able to ensure a well-established and well-coordinated response to ECHR decisions. It is important to work on the process of decision-making to the law of 2006 and to strengthen the coordination functions on the decisions of the ECHR. Another important matter is strengthening the prognostic function in the interstate statements and preparatory works that can be related with this kind of cases that can be resolved in the future. Some more specific recommendations are provided for Ukraine. First of all, the preventive recommendations. They are related to the non-repetition of the situation. And lastly, ensuring effective functioning of effective national legal remedies, domestic legal remedies, and introduction of the new methods to ensure non-repetition of existing violations and prevention of new violations, improvement of managerial practices that are related to strengthening of institutional role of ECHR decisions implementation coordinator. We need to implement the availability of effective national coordination mechanisms to resolve and to ensure horizontal work of the judicial power, legislative power, executive powers to ensure the proper executive mechanisms to implement decisions. Lastly, expert component needs to be improved through ensuring transparency and inclusive nature of this. We would like to have a more branched institutions based on analytical centers, NGOs, civil society, legal associations, human rights protective organizations to further better formulates the decisions through the dialogue with the Committee of Ministers under Rule 9 of the regulation of the Committee of Ministers. And lastly, I would like to pay special attention to the systemic structural problems that is the most resource-intensive measure, and it needs to be best forecasted in these decisions, and the time of response to such decisions needs to be shortened as much as possible, while taking into account the timelines of non-implementation. Lastly, all of those things can ensure the horizontal dialogue between the ECHR and the national legal system through broader application of Protocol number 16 for the Convention, while including all the work, while including the Supreme Court and the Constitutional Court of Ukraine into this process. Now, a few points by way of conclusion. First of all, should there be or shouldn't be the implementation or non-implementation of the ECHR? Respectively, according to Article 6 of the Convention, the legal commitments to implement this may even require amendments not only to the national legislation but also to national constitutions. The legal commitment of the Convention participating states is the duty for all branches of state power, and it cannot be avoided because of technical problems, obstacles related to the lack of political will, lack of resources, or legislation to that effect, including legislation. We cannot limit the duty to fulfill the ECHR decisions only by the tragic conditions of war, because as Ukraine is moving towards the European integration, most of the systemic structural problems are unrelated to the conditions of the war, are not based on that. They have become more visible during the war, of course, and they have taken the front seat in this context. In the context of this terrible war against Ukraine, it is becoming particularly obvious that the norms of international law are not just empty norms, but ideas and ideals that need full-fledged implementation, because they make us different from the aggressor for the whole world to see. These principles remain a key to and they ensure the support of the whole world. I would like to wish all of us new achievements in the process of implementation of the conventions, of the ECHR decisions. And these decisions are really not against Ukraine, but for Ukraine, in favor of Ukraine, to ensure Ukraine's European future. Thank you very much, Pavlo. Well, I cannot ask the audience whether or not they have the questions for you, because the audience does not have the time to ask them. However, I would suggest to invite the next speaker, who will be a logical continuation of your decisions. And if you have time, maybe we could take a couple of questions both to you and to the next speaker. Well, unfortunately, would you agree? Well, unfortunately, I need to leave in 10 minutes. Okay, clear. Okay, any questions for the audience? Change of plans. Okay, we have judges mostly in this room, and most of them agree that the decisions of the courts must be implemented, including the decisions of the European courts. I'd like to give floor to Roman Babi, Chief of Subcommittee of the ECHR Decision Implementation and Alternative Mechanisms of Decision-Making Committee of the Parliament on Legal Policy. The activity of the Ukrainian Parliament as the key integration mechanism in the implementation of the ECHR decisions and tasks and plans. I think this is how your topics will sound like. Thank you.
Шановні учасники, я хотів би подякувати.
Thank you, Irina. Dear participants, I would like first of all to express our gratitude to the organizers of this event. Thank you for finding the opportunity to organize this forum and to maintain the traditions that we started before the war. And thank you for the opportunity to discuss the topic. And I'm also grateful to all the participants, both offline and online, who are with us, because the The topic is really interesting and really relevant. The speakers have already mentioned that Ukraine is on its way to the EU integration, and within the context of integration, we are to address some issues posed by the European Court on Human Rights. And definitely all the stakeholders understand that we are doing it, we execute the judgments of the European Court of Human Rights, and we are doing it for ourselves, for Ukraine, because the problems mentioned by ECHR are really
нашій країні для того, щоб
the topics that should be resolved by Ukraine
успішно функціонувати, процвітаючи.
in order not only to become the members of the EU, but just to become a prosperous country. My topic is the activity of the Parliament in relation to the execution of the judgments of the ECHR, the tasks and the plans, and we can talk a lot about the theoretical issues, but I would like to outline some specific things happening now and which are in the focus of attention of the Ukrainian Parliament. We have lots of problematic issues that were mentioned by the previous speakers. There are certain things that have to be resolved in relation to the necessity to enforce the court's judgment, and I will probably concentrate the most complex ones. I will talk about the reforms. I will talk about access to justice. Moreover, this is one of the topics of our subcommittee. Definitely, there is the whole range of some other problems mentioned by the previous speakers. These are the issues in the penitentiary system. There are some draft laws that have already been passed. There are some more that are to be passed. There are some issues in relation to the criminal justice. Well, probably I will not talk about it because this is the ground for the other committee, and some other colleagues of mine from the Law Enforcement Committee will be able to address this topic. We also mentioned today the protest, the land moratorium, and many others. The transfer of children. Again, these are some specific issues. Definitely, they are important as well. It doesn't mean that the fact that we do not discuss them here doesn't mean that we do not do anything about it. But I would like to start with the first topic. The group of cases, Zhovner, Ivanov, Burmich, so just we know it as Burmich case, non-execution or serious delay in execution of the judgments against the state or the state enterprises. Ms. Nadia Zadoroshna has provided a detailed description of these challenging issues, and again, tomorrow we are going to have a special report of the Ministry of Justice of Ukraine and the Government Commissioner on ECHR cases, and I think these speakers will highlight the problematics in more details. I fully agree that this is a comprehensive, a complex problem. Definitely it is financially burdensome. And what is done by the Parliament? We face the primary task, and that is to improve the procedures of forced execution of court judgments. The draft law was passed in the first reading before the full-scale invasion. This is actually a new law. Almost definitely the period for proposals and amendments is over, and there are lots of controversial issues in this draft law, and the war actually pushed it at the background. And now we are going to bring it back with consideration to the decisions of the European Commission and the judgments of the court. And next week we are going to have the parliamentary hearing of this issue. And on the 5th of December, we shall discuss the enforced or forced execution of the judgments. And we do this hearing in order to understand where we are and what we should do on this way. This is the central, the major law regarding the information of the system of the forced execution of the judgments. We also have a draft law on improving the judicial supervision over the execution of the judgments. It was developed by the Ministry of Justice in combination with in cooperation with the experts from Pravo Justice Project. Again, we are waiting for the draft law to be discussed in the Parliament. Ms. Zadorozhna mentioned digitalization issue of criminal proceedings. There is the draft law 9363 about digitalizing the criminal proceedings. It was initiated by the government, and the name is the draft law is a bit targeted. It says about digitalization of the criminal proceedings, but there are some certain issues identified by the Ministry of Justice as the most urgent ones. For example, arrest in the remote way. It was recommended to be passed in the first reading. It was supported and by all the stakeholders. Definitely, we all want to ensure this digitalization of the enforcement procedures, and I do hope that during parliamentary hearings, the deputies will discuss these issues as well. Regarding Ivanov-Burmich case, the problematics here is more complicated. This is the moratorium, the legislative moratorium that has already been mentioned. I'm not going to repeat these problematic issues. We do have these challenges, and unfortunately, we still introduce the moratoria, and definitely we have to review some of the decisions, and I am under the impression that moratoria are used not in order to improve something, and this is supposed to be their primary goal, but they are used as a certain privilege in respect to those people the moratorium are used. And in some cases, the moratoria do not help address the problem, and in some cases the problems get even more deteriorated. And definitely some of such moratoria should be reviewed. We also face the budget issues, the financial burden. We really understand that the state probably doesn't have enough financial resources to execute these judgments against the state, and in order to ensure its social guarantees. And again, there should be some reforms conducted in the area of social policy, and new privileges and new guarantees should be introduced only if the state has the capacity to pay for this, to ensure these social guarantees financially. Or we should cancel such certain system of social guarantees, but it is definitely a very unpopular decision. And unfortunately, we have one more issue in store for us, and this is the payments that should be made to the military staff. The question whether the state will be able to meet these obligations is still debatable, and we have to think about it. The next block I would like to raise is the group of cases Naumenka merit, and this is the prolonged delay of criminal and civil proceedings. Ukraine is trying to optimize its procedural codes, and the codes our committee is working on. This is the civil procedural code, administrative procedural code, commercial procedural code, and I know that there are some other committees who work on some other procedural codes, in particular the criminal one, so I'm not going to address them. Unfortunately, with the beginning of the full-scale invasion, the work on this dimension has been slowed down. We have to put it back on the table, and the committee developed some amendments to the procedural codes, and these amendments were related to the peculiarities of hearing cases during the wartime. It is Draft Law 8358, and first of all, it addressed the importance of continuity of court hearing, safety of all the parties, and also it introduced some elements of the e-justice. The committee discussed this draft law, and now we wait when the draft law will be voted in the first reading. Definitely, it should be improved, but all the stakeholders who we consulted about the draft law were positive about it. Definitely, there were some remarks, but these remarks may be easily introduced before the second reading. What can be useful in order to reduce the delays or the length of the proceedings? Definitely, certain restrictions are introduced only for the period of wartime, but we actually may see whether they should be left even after the end of the war. We are talking about video conferencing that was used during the COVID period. The opportunity to participate in the court trial with the help of the phone or laptop was introduced during the COVID period, and again, everybody found it convenient. There were no particular complaints about it, and now video conferencing participation is introduced on a regular basis. And the same may be done about those elements of e-justice which are introduced in the draft law in question. And this is only the preliminary work to address the problem of excessive workload in the administrative courts in relation to social payments. I cannot provide the exact statistics, but probably out of 100, there are about 60 to 80 social cases, and the administrative courts deal with them. And there are situations when one and the same person addresses the issue twice or three times. So it means the person goes to the court or files a claim to the court 3 times. And again, we discussed these points, but it would be good if we managed to achieve some results. And again, the same is about payments to the military staff. Digitalization or automation of the court procedures. It is important to reduce the lengthy periods for the procedures, and there is the draft law that presupposes obligatory use of electronic accounts or cabinets by legal entities. So we make some progress of in the area of digitalization. We did the audit of the UCITS system, and I would like to express our gratitude to our international partners, to Travel Justice Project, to USAID, Justice Project for their help with this audit, and on the basis of the audit outcomes, will develop the terms of reference to improve this system. Mediation or arbitration as alternative dispute resolution. With the beginning of the war, there was these processes have been suspended, and definitely we have to renew these things. Well, somehow we get adjusted to the war, and we have to resume our activities in this area as well. I think that at the beginning of 2024, we shall have committee hearing in order to understand the needs in this area, in this dimension. The next block, case Volkov, Denisov, impartiality and independence of the judiciary. Here we have made some progress, particularly in this year, and it is stated by our European partners. But considering the scale of the problem, still a lot of things have to be done, and here we should pay efforts all the time. In my opinion, the politicians will always be tempted to exert pressure on the judiciary. Unfortunately, this is the so-called tradition, and the role of the parliament is great in suppressing these attempts. Everybody is following the news. I'm not going to talk a lot about it. The High Council of Justice has been established. The new rules for selection of the council members have been introduced. For almost 6 months, the High Council of Justice was inactive. Now the Higher Qualification Commission of Ukraine is established again. The new rules have been introduced. So the committee of the parliament is making its contribution to make it happen. And these are those authorities that were properly funded in the budget, considering the tasks of these bodies. The disciplinary function of the High Council of Justice was restored, and until the establishment of the disciplinary service, the High Council of Justice may be responsible for disciplinary proceedings against judges, and also the issues are discussed about the disciplinary service or the service of disciplinary inspectors. The nearest task of the Parliament of Ukraine in this respect is to improve the rules for the selection of judges, and now we are waiting for the remarks and proposals. Definitely this issue is very important to address the understaffing of courts. And also in the nearest future, I think we have to improve the disciplinary proceedings against judges. And actually there was a roundtable discussion just before the forum, and I'm grateful to the Council of Europe for inviting the European experts, and we actually were discussing these issues on selection, disciplinary proceedings, judicial ethics. These are really pressing issues. The next area of our activities is the changes to the amendments to the law on execution the judgments of the European Court of Human Rights. The goal of these changes is to update the law The last update was about 10 years ago. And the second task is to improve the constitutional capacity of the Government Commission on Human Rights. So we have the mini task force on the basis of the subcommittee, and the members of this task force are Irina and Pavlo and the representatives of the Ministry of Justice. Definitely this work it took us a bit longer to develop these topics. Well, experts were really trying to take a deep, in-depth approach into the topic, and I hope that in the nearest future, probably within a month, we shall have the entire text of the draft law. So now we discuss the very wording of the draft law.
What would we suggest? What kind of new concepts we're going to introduce into these laws? We will improve the systems of the publication of decisions, the reimbursement procedures, and the government institutions. And not the way it is done at the level of the Ministry of Justice. We need to outline the key decisions, coordination of decision-making of the ECHR, monitoring and harmonization of legislation, administrative practices, the procedures of interaction with other authorities, etc. Another area of activity that was also mentioned, I think by Pavlo, if I'm not mistaken, this is implementation of the protocol number 16 for convention, which envisages the ECHR's possibility to provide advisory opinions to the judges. In theory, it exists, but in practice, it doesn't work. In theory, there are thoughts that it might work, but according to the opinions of judges, it requires the amendments to procedural codes. Subjects of request that would have the right to address ECHR with such decisions. Discussions were also held on progress as to the Constitutional Court of Ukraine, because involvement of the Constitutional Court will envisage amendments to the law on ratification, because it defines it as the highest, the top judicial authority. At the end of my presentation, please, bear with me. I know there's a lot of work to be done. There are some achievements. They may not be as big as we would like them to be, but we're having a full-scale war on our hands. So the Parliament understands the problems best. We need to understand that we're not doing this for them, but for us. And maybe some of the participants, maybe Irina was saying that the decision of the ECHR, it may be versus Ukraine, but it's a driver of positive changes in our country. So we are trying to move towards the resolution of these problems as much as the circumstances allow us to do so. I would invite all the participants of this forum, of this discussion, to further communication. We're open for communication. The Committee for Legal Policies will be very happy to, work on your professional opinions. We will do everything possible because we really appreciate professional advice. It's very timely, and we hope we would be able to implement them in the current legislation as much as possible. Thank you for your attention. Thank you. Professional and important opinions for the members of Parliament. Anyone? Okay, we have lots of raised hands apparently. I will start with a brief reflection. Legal Policy Committee is probably the only committee of the Parliament and that at the moment is cooperating with the judicial authority and hears all preferences and calls for action that we are presenting to the quality of laws. And according to the Committee of the Legal Policy, there's draft law 5661, which you haven't mentioned, which is comprehensive amendments to the Criminal Procedure Code, even though it's not your line law. Another law was adopted in the conditions of war as to the lost materials of criminal proceedings. And this is a bit of a synergy that was already felt. And the laws that you mentioned were written while taking into account the professional level of judges and, most importantly, improvement of the quality of work of the judges on one hand, and on the other hand, the removal of additional pressure that is not pertinent to the legislation. So in terms of professional opinions, we would just like to ask to continue the work in the same key and establishment of cooperation, not only with your committee, but with all other committees that are involved in decision-making and lawmaking, the judiciary work. Dnipropetrovsk region, I would like to pay attention to an important problem that may become a big problem. The law on judicial proceedings, the termination of judicial proceedings in the case of decision, the decisions are made as to the state enterprises that are included in big or small privatization. As of now, there are enterprises, debtor enterprises, that are included in this registry since 2018. So throughout this time, the decisions are not being implemented as to such debtors. According to the legal practice, to the court practice and case law, the state guarantees are not applicable as to the guarantees of court decisions. I think this matter needs to be regulated as soon as possible. Some of these enterprises are only involved in this work. However, throughout these years of factual activity regarding privatization, well, not much has been done. Thank you. Thank you, Anna, and then Dmytro. First of all, I'll briefly say and confirm that we have very good communication with this committee. Secondly, I also wanted to remember the thought, I remembered in the context of Serhi's question related to the implementation of court decisions that were not satisfied, that did not satisfy the civil rights of the victims. It's a special problem. And in this context, I remember one document that has been sitting in the parliament for a long time, and we've already forgotten that. In 2005, Ukraine has signed the European Convention about the reimbursement of damages to persons who suffered from violent crimes. We have already forgotten about this convention, but this is the convention of 1983. Everybody has indicated that this is all a good thing. This was all wow. But in 2006, when we approached this question more closely, it turned out that there are lots of problems there. But in this specific case and in this specific convention that is already signed but not ratified, we are talking specifically about the satisfaction for the persons who fell victim to such violent crimes. Okay, so here I remembered that, and I would like the committee to remember it as well, because it contains a lot of very interesting positions. Another point, since you've mentioned that in the committee, and you will mention that probably many times again, the amendments to procedural codes and the introduction of further systems related to e-courts. You know that in our region we have all kinds of pilots on that matter. So the Supreme Court has noted on multiple occasions that there is a problem between instructions and its coordination with the procedural code. A very important question which we need to regulate as soon as possible. There are some nuances there. Yes, exactly that, related to the e-court and all the modules. A very important question for me as an administrator who communicates with the budget. Spending money on notifications to persons, will note that we have all those electronic messages. Our Supreme Court tells us no, 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 but something needs to be amended in the procedural legislation. This can be done fast. We don't have to make a whole big systemic thing. It could be a small draft law that would resolve this question. It means a lot in terms of money. This will release a lot of money to be spent on other more important goals. Thank you, Roman, for your presentation, for the information that you noted. But since your report was about the procedures of the Parliament towards the ECHR decisions implementation, I would like to note the procedural problems related to individual legal remedies adopted by the High Chamber, by the Grand Chamber. I mentioned these problems in 2018, but now there is a chance to work on this on the individual basis and this new team. A few points there. First of all, there is a problem with a 30-day term for the consideration of applications of the applicants who received positive decision of the ECHR in their favor, and according to the terms, the 30 days, only the materials will arrive in that case from the first instance, and it's not possible to do this within 30 days. Even automatic translation may not be available. So first do what we need, then authentic translation, and then the proceedings start. This term was never maintained. Starting from the beginning of 2018, we may say that 100% of violations of this term is based on the fact that it's unrealistic to resolve that. Secondly, the so-called authentic translation of the ECHR decisions. The work of the Grand Chamber, the norm of procedural law says that authentic translation is requested upon the decision, upon request of the applicant. Sometimes that applicant forgets to write that application, and then they say, well, you don't have translation, and you should have requested, and then he sends a request and says, please request translation, and it's a completely extraneous action. The judge looks at the proceeding or the collective Grand Chamber. They can request that authentic translation automatically in all cases whenever the applicant fails to provide it. Then there are some problematic issues related to postponement of court decisions. This matter is unregulated, and then one court decision may review the provision of complex decision and the ECHR, for instance, in criminal proceedings, and it's almost completely unrealistic. This week, we started the consideration of the case on the implementation of Saslova and Batykyan case versus Ukraine. It took 6 months, and the case is about ordered murder. And the decision of the ECHR is probably the most serious one in all the 6 years of all those lately adopted versus Ukraine. So we need to regulate all procedural laws on the matter of postponement of the court decisions, or the possibility of postponement through inappropriate notice to the case participants. Similarly, we could consider the review of the cases without the court trial. In some of the cases, this is the procedure that is, burdensome, where we need to adopt decisions, where we know that judges' decisions need to be abolished after this decision of courts of the courts adopted versus Ukraine, and the administrative courts and the CPC decisions, administrative code, also requires decision-making. And the proceedings, I will explain what kind of situations we mean. For example, the decision of the European Court for Burmach versus Ukraine. There's nothing to review there, but the momentum starts rolling. We open proceedings, we close proceedings because there's nothing to review. So basically, there's a problem because the currently existing norms are pretty imperative in terms of the judge's actions, but they're illogical. And in many cases, they do not meet the situation where the decisions of the courts cannot be adopted through additional measures. And for example, in terms of the duration of judicial proceedings, the reasonable terms are violated. The decisions are wrong as it is, but the mechanisms come in and on and on. And since there's no chance to adopt these procedural actions, then basically some of the procedural actions are taken just for the benefit of the process. This shouldn't be happening. And the last thing we faced within the last 2 years, it's also very interesting. The ECHR has started adopting court decisions more than 10 years later after the last decision at the national level. In all procedural laws, there's a statute of limitations, and there's a possibility to review the national court's decisions on exclusive situations if no more than 10 years passed since the adoption of an initial judicial decision. The European Court has adopted multiple such cases on Ukrainian cases, adopted back in 2010, 2009, 2011. And in 2 cases, the Grand Chamber mentioned that because these violations are lasting, and the applicant still sustains negative consequences, we did not take this into account. And I think the same practice, the same experience could be introduced in the procedural laws. If this is valuable, I'll be happy if you could take this into account. Should the Grand Chamber review decisions of the European Court to be able to establish the facts, particularly in the criminal cases? This is a very interesting question. Given the decisions, the kind of decisions that the European Court sometimes takes, given the consequences towards the implementation of the procedural norms, it seems like the limited possibility to intervene in the facts, limited possibility is necessary. For instance, the limited possibility to intervene in the assessment of evidence. That pertains to the judicial system as such, because this is done for exclusive reasons, and we're saying that we need to do this within the ECHR, and a special procedure may be adopted to approve certain facts by the Cassation Court in order to appropriately decide on the ECHR and not transfer this to the first instance court or appellate court because they had to assess 1 or 2 evidences and they received the case for the whole overhaul, and then they would not be able to just decide on 1 or 2 issues. They will have to fully review the case, and sometimes it is not possible. Sometimes there's no witnesses, there's no evidence, so sometimes it's just not possible. So while understanding these problems, we can set certain boundaries, and international experience could be useful, and the Ukrainian experience is pretty valuable as well. Thank you. Thank you. Hand was raised there. Somebody had a question or a comment? No? Roman, you had a comment? No, basically, well, yeah, I just wanted to say thanks to Dmytro for these proposals. We can talk more about this after the forum and maybe exchange contacts within the context of, 10 years of work. We've discussed this at this mini group. It's not as easy as it may sound. It's not such an easy question because we need to maintain balance between the stability and predictability of court decisions and the matters related to making sure that the rights of the applicants are not violated. If there's a big fee or the payment is lasting, okay, we may, be brave to take it on, but not everyone is brave enough to take it on. The decision has to be comprehensive. It's a sort of comment off the top of my head. By way of information, I will say that part of my presentation will be related specifically to the problems that emerged in the Grand Chamber over the past 5 years or 6 years, and the things that have accumulated when, we can discuss this. And we can talk about the mechanisms of exclusion of the situation where the mechanisms are obvious. Thank you. If you don't have any questions that are super effective to the legislator, then I am obliged. Well, understand, the proposals may not necessarily come in right now. You may, think about this after the forum. Maybe you would sort of digest those interesting thoughts. You have official contacts of everyone. You're welcome. Thank you, Roman. You have sold this super effectively. I would like to thank everyone. I think Natalia would join me in saying that despite all the security measures that we need to adhere to, despite the fact that our event is not very numerous because of the security measures and because of the war that we are all sustaining, the forum has started breathing again after it has been suspended for online work because of the war, because in the quarantine. The first day is pretty effective.
Бажаю всім гарного вечора. Бажаю всім гарної
Have a
вечері.
good evening. Enjoy your dinner. Try to find at least one time for yourself. Try to have some rest. Enjoy this beautiful city of Lviv, and we invite you to join us at dinner. The dinner will take place in Mr. Hotel. It's to go through the park to the hotel. So we invite all of you